Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation, and you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Here's my response.
Well, I'll say that. Once again, Judge Brown is another one of our felony judges. He is doing arraignments too. So you want to make sure that your paperwork says Judge Ketchell. This is Judge Ketchell's court. And if you have any doubt, I have a list of names up here that you can come up and check. All right? We'll do this. All rise, please. The circuit court is now in session. The Honorable Terrance Ketchell presiding.
Please proceed. Sorry for the delays. It's an unexpected situation in jail. So, how do you want to proceed? I'm not sure exactly who's here. You just want me to go down on the pleas and do the out of custody? Okay. So the first out of custody I have for Mr. Medina is Baldino, Richard Baldino.
I'm pretty sure Mr. Baldino was sentenced to DOC through drug court just the other day. I think we had done a global drug court deal a week and a half ago, and then he promptly absconded, and Judge Ward has sent him off to prison.
Okay.
I don't think he's on the dock.
Okay. So those are the only one I have for you. Is Joseph Beckworth here? Come up to the podium with the state announce.
Your Honor, we have Joseph Beckworth here on 23 CF 1055. He's charged with 1 count of sale, manufacture, deliver marijuana, 1 count of reckless driving, and 1 count of driving while license suspended or revoked. The state's offer today is a withhold of adjudication, 24 months of probation, and that would be 1129 probation on the reckless driving, concurrent with the 24 months on the sale, manufacture, deliver, and 1129 on the driving while license suspended or revoked, concurrent with the sale, manufacture, or deliver. Substance abuse evaluation within 30 days, treatment to begin within 60, random urinalysis, 24 hours of community service, advanced driver's improvement course, no drugs or firearms during supervision, maintain gainful employment or 2 applications a week, and of course, court costs and fines.
Okay. Mr. Beckworth, that's a mouthful.
Yes, sir.
You do have a right. The purpose of today's hearing is to basically place a plea. If you're interested in the state's offer, we can pursue that. You do have a right to have an attorney to assist you. You cannot afford one will be appointed. You'll have to fill out the forms. We can enter a not guilty on these, and you can talk to your attorney if you wish. How do you wish to proceed?
I'm going to go with the state's recommendations.
Not a recommendation, it's an offer.
The plea. I did get my license back last week, so I approved of that. Got my SR22 insurance and all that. Got that all paperwork for that.
So if we do that, the only issue that we've got, we need to do it in writing. Assume you don't have all that in writing, as far as in the plea form.
I don't have a plea form, but if the public defender would be so kind to give me a plea form, I would be happy to write one up. And if they'll show me proof of his driver's license, we would amend the driving while license suspended or revoked to no valid driver's license to save him that.
You want to write it or type it?
You want to type it, Mr. Gates?
I don't need a copy of the type it. Or you can write it, it's your copy.
I'll write it out. Okay,
You got one copy?
While she does that, sir, put the seat down on the bench. Right back. And start.
That's my bad.
Okay. Is Shanna Bland here today?
Bland.
B-L-A-N-D.
I thought you had.
Is Mr. Harper here? Mr. Harper here this afternoon, Drew? Okay.
Is he supposed to? Has anybody seen Mr. Harper?
Your Honor, if the court remembers, he took care of his case this morning, I think he thought that was it.
Okay. So, his plan, we're here today on case number 2023 CF 1069. Purpose of today's hearing is just to enter a plea. I know you've had an attorney appointed already. He's not here. I actually know why he's not here. It's not his fault. But what we're going to do for today, so you can kind of continue to move forward, is we're going to enter a not guilty plea on your behalf. So you have a chance to meet with Mr. Harper. And then we'll come back here. We're going to come back here on our regular pretrial docket, which is not until August, the next cycle, August 14th at 9 a.m. But when you talk with Mr. Harper, if he's in discussion with the state or whatever, he needs to have a hearing before then we can get special assessed, okay?
Okay.
Okay, any questions?
No.
So that preserves your rights. By entering a non-guilty plea, you don't give up any of your rights. Okay? Very good, thank you. So, Joshua Bigland.
He wasn't in here when I gave his speech about short-term or rats. So do you want us to have him go and change?
No. No, let's just do it. Mr. Bigland, you're here on case number 2023 CF 1005. The purpose of today's hearing, as you heard me state earlier, was to enter a plea. You do have a right to have an attorney appointed. If you can't afford one will be appointed. Is the state wanting to make an offer on this case?
Your Honor, today the state's offer is 6 months Okaloosa County Jail.
Okay. So what I would suggest on that, you're welcome to accept that plea if you want here today, but generally when there's an incarcerative sentence involved, I would suggest that you accept the appointment of an attorney, meet with your attorney, the court will enter a not guilty plea here today so you don't give up any of your rights. You can talk to your attorney and then go from there. Do you wish to have an attorney appointed?
Yes, sir.
Okay. Court will appoint the public defender. Court's going to enter a not guilty plea. We'll appoint the public defender. You do. Do we have some forms? You need to fill out this form before you leave the courthouse. Your filled one. Just hand it in to the clerk before you leave.
So, you get sir, right here, sir.
I think you already filled one out.
We already did it.
We've got it up here, I think.
All right, just fill it out. Oh, he's still working on it back in his queue, so just turn it in the clerk's office before you leave.
Okay? Any questions? So, our next court hearing, I don't need to tell you that, is August 14th at 9 a.m. Okay? Yes, good, thank you. Malik Bradshaw. Malik Bradshaw. Did the state announce?
I have a warrant for Bradshaw, which is probably right.
This is case number 2023 CF 1031. Is the state requesting anything?
The state's requesting a capias, Your Honor.
Court would grant capias, no bond. Ms. Bridget Buskey. Mr. Medina, I believe this one's your case?
Yes, Your Honor. Ms. Buskey is present and approaching. Oh, sorry. Steve Medina with Bridget Busky in, is it, did I pronounce it right? In 23 CF 984. She's provided me some information that I need to review with her. If we could just plead not guilty today, and she will set up a meeting, and I guess she would be on the August 14 docket.
Correct. So we'll come back on August 14th on the pre-trial at 9 a.m.
You'll meet with me.
Meet with the attorney, obviously, beforehand. All right.
Thank you.
Thank you. Willie
Did
Carter.
Mr. Bigland forget his paperwork?
Yes, sir.
Willie Carter.
Yes,
Just
sir.
no attorney.
I'm coming, sir.
Okay. Take your time.
Yes, sir.
Would the state announce on this and tell me if there's state?
On Mr. Carter, Your Honor, we're here on 23 CF 918. That was a felony, driving while license suspended. It's been transferred down to misdemeanor court. He doesn't have a date to appear yet, according to benchmark, but it will no longer be in this court.
How is he gonna find out when this next court hearing is?
They should mail something to him. It was just placed on the docket today.
Okay.
We have to wait on an information to be filed into,
So what's gonna happen, sir? Your case, this is felony court.
Yes, sir.
Your case was transferred to misdemeanor court,
Thank you, sir.
which is probably good for you.
Yes, sir.
So, but it's it's just been transferred, they don't have it scheduled yet.
Yes, sir.
Somebody's gonna contact you and tell you when your court date is,
Okay, sir.
okay?
Yes, sir.
So do we have an address to make sure that he gets the right address?
well, I can certainly,
I can give it to you, sir.
yes, sir.
Go ahead.
9657
Got it.
Very good. Thank you, sir.
Yes, sir. That's
Somebody will contact you.
Thank you, sir.
Thank you.
That's it.
Gabrielle Chavez, if I pronounce that right. Mr. Diaz, your case also.
Steve Medina with Gabrielle Chavez, 23 CF 61. I have some information, Judge. I called for my clients before. If he can sit down, I'll get with him. It may be that he wants to resolve the case today. I
Okay,
apologize.
so there's been an offer that's been made.
There has been an offer made to me that I need to communicate to him.
Why don't we just pass over it and figure out where we're going? Okay. Kevin Danke, if I pronounce that right?
Yes, he is present, Your Honor. Steve Medina with Kevin Danke in, is it Danke or not?
Danke.
Yes, they're in 23 CF 1036. He has a PTI offer. If Ms. Sandler could please communicate to Ms. Sharpless that I would like the PTI terms put into an agreement so that I can go over with him, but he does want to accept PTI with a plea. And so I'll go over that with him to make sure he understands it. And if we could just remain on the August 16 docket, Your Honor, or excuse me, August 14.
We can, you know, if it looks like it's gonna be put together pretty quick, what we can do is come back on one of the, continue this arraignment, and come back on another arraignment docket that we have, beginning of July, so it might make it faster, or we can come back in August. either way.
July sounds good, Your Honor. That's fine with him, Your Honor.
Okay, so why don't we come back July 11th? Oh, no, July 18th, let's come back to 18th.
And, Your Honor, I can draft the pretrial intervention agreement fairly quickly. If Mr. Danke wants to hang around for just a minute, I'll have it on the printer as
So if you want to try to do the agreement today, we'll do our best to put the paperwork together while we're doing other things, okay? So you can sit back down. Thank you. Try to get that out today. Is that okay, Ron?
That's great, man.
All right.
Thank you.
We'll work on it. Thank you.
Okay,
Thank you,
the
man.
last one that I have that's not it's not incarcerated for today from Mr. Medina is Mackenzie Eschke.
Yes, sir.
Last name, man.
Eschke.
Eschke.
Yes, Your Honor, she is here, and obviously, on behalf of Ms. Mackenzie E. Eschke in 23 CF 1038, I would like to enter a plea of not guilty and keep her on the August 14 docket, and she's going to be retained.
Very good. Court will enter a not guilty plea. We'll continue this to the pre-trial, August 14th at 9 a.m.
Thank you, Your Honor.
Thank you. We have a Reno Gamble. To state, want to announce this?
Yes, Your Honor. Mr. Gamble is here on case number 23-1025. It is a single count of child abuse that has been filed in the state. We would anticipate making Mr. Gamble a PTI, pretrial intervention offer, because he has been extremely compliant per our discussions with DCF, and we'd like to offer him that opportunity.
Do we want, should we appoint counsel so he can help coordinate that? Does that make sense, or can he do it without?
I don't know if he feels comfortable proceeding without counsel, because he
So
would still
let
be
me just say
subject.
this to you. You have a right, you've been charged with a crime, you've been cooperating, that's great, DCF, that's very important. But you do have a right to an attorney, okay? And the court, I'll be glad to appoint you if you can't afford one, I'll appoint the attorney today. You can meet with the attorney, make sure, coordinate everything with the state. If you want it, just go ahead with that, and I'll allow it if you don't want an attorney, but if you feel uncomfortable, you want to make sure you understand what you're doing with this. It's always good to have the advice of counsel.
Yes, sir, I feel more comfortable.
Okay, so the court will appoint the public defender. You've got to fill out the application form. Leave it with the clerk before you leave today. We'll go ahead and enter a not guilty plea on this, and we'll schedule it for 8/14, which is a couple months off, but something will probably be able to be worked out in the interim, it sounds like.
Yes, sir. What we'll do is we'll go ahead and get that over to the public defender's office so that they can discuss it with him and see if that's an option.
Evening, Your Honor.
Looking at 9 o'clock, 8:14?
Yeah, 9 o'clock.
And Mr. Gates, would that be your case? Great.
I'd like to limit my cases with the response if I can.
The inmates are here, so you know.
Okay? We'll just, we'll go through them.
And I did tell court security over, given that inmates just arrived, we probably need a bit of a recess so we can get the plea agreements taken care of.
Okay. 1, 2. I've got several that would end up being appointed to you, Mr. Gates, that do not have attorneys yet. Can we go ahead and start, probably just appoint and have to meet with you later?
Are there inmates in the building?
The inmates are back there right now.
Mr. Medina, the inmates are here. Do you want to talk to some people?
As soon as I get one guy out of here, yeah.
Okay, because I'm going to take
Go ahead. You want to talk to somebody? Go ahead.
I'm going to take my unrepresented now and then go.
Fine, go ahead. Can I just call Chavez
Sure,
and get
sure,
him out of
sure.
here?
Yeah,
And then I'll go talk to inmates?
okay.
Gabriel P. Chavez, if I could call him back. 23 CF 1061. Your Honor, he has a credit for time served offer, but it's on a felony, so he and I are going to have a meeting and he's going to plead not guilty today.
Okay. There we go, plead not guilty. We'll come back on August 14th at 9 a.m. for a pretrial.
Yes. Thank you, Your Honor.
Okay, thank you.
Thank you, Terrance. Just step back.
Next is Sandra Garcia, not currently with the attorney. Should the state announce?
Yes, Your Honor, this is Ms. Sandra Garcia, case number 23CF964. She's charged with grand theft and fraud swindle to obtain property under $20,000.
State wanting to make an offer?
Yes, Your Honor, at this time, I would accept an offer of a withhold of adjudication followed by 3 years of probation, during which she needs to complete an anti-theft course, maintain gainful employment, complete 50 hours of community service work, have no contact with the victim, pay her court costs, and then also we will reserve jurisdiction on restitution for 180 days.
So that's quite a bit. He ran through it real quick. The purpose of today's hearing, as you heard me say already several times, just to make a plea. You do have a right to have an attorney appointed. Talk about this. They'll leave that offer will be on the table. They're not going to close it today. You wish to have an attorney. First of all, you want to have an attorney appointed? Or you want
Yes, sir.
Okay. The court will appoint the public defender. The court will enter a not guilty plea that will preserve your rights here today. Then we'll come back on 8/14 at 9 a.m. In the meantime, between now and then, you can meet with your attorney, talk about possible plea, etc. Okay? Any questions?
Application.
A PDF.
There should be one out already.
Oh, okay, I'm so sorry.
Did you fill out your application already?
Yes, actually, I have that one right here.
You got it.
You got it.
Okay, thank you. Yep.
And then I think that I have it, I thought I had it.
Destin Gregory. Would the state announce?
Correctly. Judge, this is Mr. Destin Gregory, case number 23CF948. He's charged with possession of controlled substance without prescription and narcotic equipment possession as well. The state would accept an offer of adjudication of guilt, 24 months of probation, $615 court cost. He would have to complete a substance abuse evaluation and any follow-up treatment that's recommended. And he would also be subject to random urinary analysis during probation.
So, you heard me talk to the other folks. You do have the right to an attorney. If you can't afford one, one will be appointed for you today. If you're interested in pursuing that offer, if you want to talk to your attorney, don't have any problem with giving me an opportunity that they're not going to pull it. So, you wish to have an attorney appointed, that's first order of business.
Yes, sir, I have an attorney.
Court will appoint the public defender. Court will enter a not guilty plea on your behalf so that you don't give up any of your rights, and we'll come back here on 8/14 at 9 a.m., okay? Meet with your attorney in the interim.
Here to fill out. Mr. Gregory, do not leave.
Fill that out before you leave, and bring the paper and come back.
Lacey Hammond.
Your Honor, Travis case that we have from Ms. Lacey Hammett. At this time, we're going to be entering a not guilty plea. It's already scheduled for August the 14th at 9 a.m.
Very good. The court will enter a not guilty plea and we'll come back on 8/14 at 9 a.m. Thank you. Mr. Edward Hatch. Would the state announce on this?
Yes, Your Honor. This is Mr. Edward Hatch. He's charged with grand theft. Your Honor, give me 1 moment. I need to pull his offer.
So while they're looking at pulling up the offer, as I said to the other defendants, you have the right to have an attorney appointed. If you can't afford one will be provided to you. But if you want to consider their offer, let's see what it is.
Yes, Your Honor, this is a probation offer. Adjudication will be withheld. He would have 2 years of probation. He would have court costs of $515, no contact with the victim, or no violent contact with the victim. He'd have to take an anti-theft course. In addition to that, he would need to write a letter of apology to the victim and give that to probation. The defendant would be allowed to early term after 12 months if the other terms of probation have been completed, and restitution is in the amount of $2,200. He would have to pay that.
A lot of details there. I don't know if you got all those. So you are welcome to consider that if you wish to. But if you like to have an attorney appointed, you can't afford one, I'll appoint one today. You can discuss it with your attorney and come back and figure out what to do. What would you like to do today? You want an attorney? You want?
I need to do an attorney. I'm currently a DOD employee, so that whole spirit is
Currently what?
a DOD employee.
Okay.
So I can't plead anything other than the not guilty. And this has to go further with the lawyer.
Okay.
And we can get an application, but it's.
It's already been filled out.
You see.
Okay. Let me check the badge. I don't know that I got one.
I gave it into the clerk's office earlier before court.
Okay.
So I'm gonna point. Your application has to go through. If you're a DOD employee, it's very likely that you're not gonna qualify because you make too much money.
Okay.
I don't know that to be a fact, but I'm guessing that would be the fact. So they'll let you know. I'll appoint it today. They'll kick it back and say you're not approved, in which case we're still going to, I'm going to enter a not guilty plea here today on your behalf. That won't give up any of your rights. And we'll schedule a hearing to come back on the next pretrial, which is on August 14th, 9 a.m.
I already received that same letter
Okay.
with the same information you just stated. And the only thing I need to request back, because of what I just suggested, or informed you of being a DOD employee, my government credentials were never returned to me after I was released. And my employer right now is pretty fumed over the scenario because of that scenario.
Well, I'd like to say I'm sympathetic, but I'm probably not. So, what you need to do is talk to your attorney who's going to be appointed, or hire one of your own attorneys, and I'm sure it'll get worked out. I honestly don't know exactly what the protocol is for that, so I can't really help you. I mean, you can if you file something, but not here today.
Okay.
But do you know, does the state know what the situation is on this?
On his DOD credentials, Judge?
He says he had them removed from him and nobody gave them back to him. What are the credentials? Are they like an ID?
Is he talking about like a physical?
I don't know.
I'm physically talking about these two identification cards that are my credentials for the government employment that I currently hold.
So it looks like they've been returned to you, sir.
No, sir. I had to go through the scrutiny of getting them back through my employee. This is last month when I got charged for this and was arrested for this. I had to go back to my work and get these issued.
So the sheriff's office may still have them, or whoever arrested?
I contacted the sheriff's department that arrested me. I actually contacted my arresting officer, and he stated he did not have them, is what he stated to me.
He didn't, but he took them from him, but he didn't have them, and he didn't have any idea where they were?
Yes, that is what he informed me.
Your Honor, I don't have any information on that today.
You might go above his head with the sheriff's office.
Well, my legal back at my base is I work for NES Jacks, and they're the ones that we're supposed to be, because right on the back side of the ID it says if lost or found, even if the law enforcement were to take them and not return them, they're supposed to mail back to the Navy base or the military base that I work on.
Gotcha.
And then they were never returned, and that's where the issue lies.
Right. Well, again, you're welcome to kind of try and continue to work directly with the sheriff and try and communicate with somebody. If somebody took them from you, you would think they would at least be able to tell you where they're at or who they gave them to and try and help track it down. I think, and we deal with a lot of military people, and I think the sheriff would be somewhat familiar with some of this. I'm not, but they might be, and they should be. So I would do it, but once you get an attorney and have the attorney try to do it, try and follow, you have to figure out where it's at. I have no idea.
Okay.
I've been doing this for a long time, never had anybody ask me the question you just asked me in 17 years. So, it's probably because they gave it back to them. So, I don't know. I'm sorry, Ken. So 8:14, 9 a.m., talk to your attorney about what your materials there, and hopefully they figure out where they're at.
All right, thank you.
Good luck. Jordan Kimmel. The state announced.
Yes, Your Honor, this is Mr. Jordan Kimmel, case number 23CF715. He's charged with grand theft between $750 and $5,000. The state would accept an adjudication of guilt followed by 2 years of probation, court cost. While on probation, he would need to complete an anti-theft course and then also maintain gainful employment. If he's unemployed at any point, he needs to be doing at least 4 applications a week.
What about the capias for the failure to appear on this charge?
Is there an outstanding warrant for him, Your Honor? I would ask that he start going on. Was that issued earlier today? When was it issued?
No, it was issued May 17th.
And
May
that's for
5th.
23CF715. This is 23.
It was a different case.
Who was it issued by?
23CF659, I'm sorry, Your Honor.
That's correct. The capias I'm holding is 23CF659, same defendant. But it was issued in, like I said, on May 17th of this year, 2/23.
Was it issued
And
by?
You can look at it.
It was from your plea day on.
It's a plea day. He did check. You aware you had another case, sir?
Sir, so what had happened with this is the first time I got arrested for this charge, the judge had changed the charge that day, and then they reissued a warrant. I already got picked up on that warrant. It's been a miscommunication on whoever is filing the paperwork for you guys. I've been locked up on this twice already. So as far as I understood, it was already taken care of. I just got released off the.
Your Honor, he's here now. I ask that we withdraw the capias. I hadn't filed on it. And this just goes as a good warning to him to be sure to continue on top of it.
So, Mr. Kimmel, you do, as you heard me say to the other defendants, you do have a right to have an attorney.
Yes, sir.
If you can't afford one will be provided to you. You wish to have an attorney appointed, there was an offer that was made. I don't know how close you were paying attention to that. I don't know if you're interested in considering that, or we can talk to your attorney and then go from there.
I'd like to get it.
Okay.
Thank you.
Court will appoint the public defender. The court will enter a not guilty plea on your behalf to protect your rights. We'll come back on 8/14 at 9 a.m. for the pre-trial for the next hearing. Okay? Meet up with your attorney in the interim. We'll get you the contact.
Your Honor, are you withdrawing?
Withdraw the capias on 6/5/9.
Want that one set for the 8/14?
Sure, we'll set both of those for the 8/14. We'll run them together.
You got your next court date, bud?
Thank you.
Session misdemeanor 814. Yes, sir.
It's little, it's the same charge. A little weird.
2 different days.
I don't know, well, you guys can work it out.
Thank you.
So,
2 different days.
next is Jonathan Knight, this one, Mr. Gates' case.
Written plea not guilty filed in his case already, Your Honor.
Okay, thank you. And you have the return date.
Yes, Your Honor, August the 14th.
Okay. Is Jakemi Scott here? Anything filed on that in writing, that we have a private attorney that's listed? Lyle Mazin?
I have one for Mr. Terrance.
What's that?
PC one, Mr. Chair.
I'm about to go to.
Your Honor, I have had communications with Mr. Mazin.
Is there a plea entered by any chance, Madam Clerk?
Oh, as far as Mr. Scott,
Right.
well, I do not have a not guilty plea for Mr. Mason. There was a not guilty plea back on May 2nd, but the defendant failed to appear, and a KPS was issued, and then Your Honor recalled it and put it on today's date. And notice was sent to Mr. Mazin, the attorney of record, and we haven't received anything.
Counsel? What is the state asking?
I'm just going through my emails with Mr. Mason. I'm not sure if he was aware.
We sent notice on May 11th, Mr. Roscoe.
Is he local?
No, Your Honor, he's in South Florida. I don't want to ask for a capias. I have been in communication with Mr. Mason. I think that this is probably some kind of mix-up between him and his client. And
So he still has not had a plea. How do you, I'm not gonna enter a plea without his attorney being here. Do we want to come back on another arraignment date? And figure out where to go from here?
I think that would be the best course of action, Your Honor. In the meantime, I will send him an email and let him know when we reset it for, just to make sure that there's no confusion.
When's an arraignment a month or so out? It would be July 11th or 18th.
Yes, sir. And Mr. Mason did file the not guilty plea.
Well, he did file it.
Yes, sir, on May 2nd. The defendant failed to appear and you issued habeas back in March. Then the defendant went and got Mr. Mason, and Mr. Mason did a motion in order for you to recall the habeas, which you did, and put it on today's docket.
But if there was a not guilty plea entered,
Yes, Mr. Roscoe, it was done on May 2nd.
okay, and so why don't we then put it on our regular pretrial on 8/14 at 9. You can still do the same thing, run him down and figure out what's going on.
I'm sending an email right now.
Tell him about this.
I think he's aware of that word.
All right, set for 8/14, and the system will send notice to him.
Okay, very good. Okay.
What, at 9 a.m.?
Yes, sir.
So those are all the out of custody cases that I have. Is anybody else that's here that thinks they're supposed to be here at a hearing that I didn't call? We have some folks in the jail.
Everybody here waiting for an inmate?
Okay. So, do we want to just proceed with the inmates?
Yes, Your Honor.
Mr. Powell, what's your client?
Good afternoon, Judge. I have Keith Golden on the docket.
Is that on the plea docket?
Sorry, it's on the 2:30 docket.
Okay. Hang with us then. We've still got a little delay out of the jail, so we're running a little late.
No rush to it.
Okay. So,
It's got to be played out. All of
Yeah,
these
why not?
18 blanks.
yeah, let's go ahead and start reading.
Did you get those plea agreements back there?
Good, and line up the inmates for me.
Starting with Mr. Medina's.
So it's still working on Allen and Atkins. So,
I'm gonna go talk.
yeah, disregard actually, because it doesn't seem like they're ready. Well, you want to take a break there, they're not ready for the inmates.
I can take some, Your Honor. We have plea agreements worked out this morning that they need to go over. So I want to just report things about.
Well, I'm in the same position, yeah, I've got to send two back if I can.
I can take Gallo Gordon right now.
Is that what you want to do, or you want to get
We can do Mr. Powell.
Okay.
Powell, Mr. Powell, you just doing a plea today? What are we doing?
We have a plea agreement.
Come on, let's get your thing.
And I will try to get back as soon as I can.
Your Honor, I just have two people I can get out of jail if I just have a few minutes to run.
Go ahead, take your time.
And Judge, I believe Ms. Bosell did want to be here for this.
Where's she at? We lose her?
I think.
Oh, she's, okay, we'll wait. You can come up to the podium if you want, with your client.
Sorry, Judge.
Is your client, oh, that's right, your client's incarcerated.
No, he's
it's
not.
not.
He's in. Vote out for the record of having Keith Golden, 21 CF 2522.
Okay, there we go.
And Judge, could Ms. Bosell and I approach this? I do.
Okay, sorry.
Come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, And I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Just based on our conversation at the bench, Mr. Gold will be entering a plea of contest to the court, and I have a negotiated plea agreement.
Would you just go ahead and announce it, the terms of the agreement to the court?
Yes, it would be a period of 5 years probation, a sex offender designation, no unsupervised contact with minors, no devices capable of internet access or social media, and count 1 would be as charged, and count 2 would be dismissed.
State?
That is the state's agreement, Your Honor. We would announce a null clause of count 2. We are agreeing to the 5 years of probation and designation, and as to the adjudication or withheld, the state is asking that the court adjudicate based on the nature of the charges.
Do we have a score sheet? There it is.
Yes, sir.
So, Mr. Gold, would you please raise your right hand? So, do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of your plea agreement. And I see those same terms are contained in the written plea agreement that are contained, that you have signed in the back. First question, did you read this agreement closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you understand all the legal ins and outs of this agreement? Importantly, you're waiving the right to go to a trial on this. This will be a final adjudication of this case. Do you understand that?
Yes.
But you are waiving some valuable legal rights. Gone over that with your attorney?
Yes.
Okay. And you're entering into this freely and voluntarily. Nobody's coerced you to get you to enter into this? Very good. Based upon that, the court will accept your plea agreement, and there will be an adjudication of guilt. And the court will, on this count 1, will sentence you to 5 years probation with the sex offender designation, no unsupervised contact with minors, no devices capable of internet access, no internet access, or social media. What's F/CC?
So fines and court costs. I wasn't sure what the minimums were.
Do we have those kind of, what are
So
they?
it's going to be $515 and an additional $151 crimes against minors fee.
Okay. Very good. Okay. Any questions? Okay, good luck.
So I'm going to get your fingerprints in 30 days.
Thank you. You do have 30 days to appeal this, Mr. Walton. Sorry. Ms. Sandman?
Your Honor, Mr. Beckwith just signed a plea agreement with the state.
Okay. You want to go ahead and? Yes, I do.
If I may approach.
You may.
Mr. Johnson? Step back.
And for the record, the score sheet is included. He scores under 22 points, which would not make him eligible for incarceration. For Mr. Beckwith showing up today, the state has given him the consideration of possession of marijuana under 20 grams, as a lesser included on count 1. He showed proof of his driver's license, so the state has given him a no valid driver's license as a lesser included on count 2. The state has dismissed count 3, reckless driving, because he received a citation for speeding, which he has already paid in county court. He will have 24 months probation on count 1 with a withhold adjudication, 6 months concurrent probation on count 2, substance abuse evaluation and treatment within 30 days, treatments begin within 60 days, 24 community service hours, advanced driver improvement course, maintain his employment or 2 applications per week, no drugs without prescription, no firearms. I believe it's $615 in court costs.
And one you skipped over? Random UAs.
Random UAs.
Okay. So, Mr. Beckwith, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God. So, I need to ask you some questions to try and establish 2 things. One, that you understand what this plea agreement is.
Yes, sir.
Even though you're not a lawyer, so I'm going to ask you some questions about it. And secondly, whether you're entering into this freely and voluntarily. Okay? So as to the first thing, you heard the attorney state the terms of the plea agreement.
Yes, sir.
Now, I want to make sure that, you know, as I mentioned to you before, you do have the right to obtain an attorney, have them consult with you. Do you believe that you understand enough about this? Did you read through the recommendation?
Yes, sir.
I saw you standing there reading it, but I want to make sure you're comfortable that you understand the crux of what's in this agreement, because there's a lot of legal stuff in there, right?
Yes, sir.
Do you feel comfortable entering into this?
Yes, sir.
Okay. Do you feel like you understand by entering into this plea agreement here today, you're waiving some valuable legal rights? Right? To trial, to confront witnesses, etc. Do you understand that?
Yes, sir.
Limits your right to an appeal, although you do have 30 days to appeal it afterwards. It limits your rights on the appeal, actually. Do you understand that?
Yes, sir.
Do you believe this is in your best interest to enter into this plea agreement?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept this plea agreement. And the court, as to count 1, will be the lesser included offense of possession of marijuana over 20 grams, lesser included of no valid driver's license, count 2, and dismiss count 3. And as to count 1, the court will sentence you to 24 months probation. As to count 1, that's count 1. As to count 2, you will receive 6 months of probation. It will run concurrent with count 1, so it'll run at the same time. So it's a total of 24 months. In addition, you've got some other important things to do: substance abuse evaluation and treatment, random UAs, community service hours, advanced driver improvements, fees and costs, etc., that are contained in here. You understand all that?
Yes, sir.
Any questions?
Yes, sir.
Okay. Good luck. You do have 30 days to appeal this, if you wish, and make sure to talk to probation before you leave and set a time to go right over there to check in and stuff. Stay in good contact with your probation officer.
Thank you, sir.
You want to bring, who do we have to come out? Who do you have?
I have the P's, I don't know if the P's ready or not.
Mine's sentencing, Your Honor, so I would ask to be held until everyone else is done.
Okay. Mr. Weinstock, are you here for Alan?
No, Your Honor, he's here for Mr. Bryan.
Okay. Mr. who?
Bryan.
Mr. Bryan,
Oh,
Your Honor,
Mr.
that's the-
Bryan.
Yes, sir, he's my witness
Bryan,
for that.
okay. Gotcha.
I think that one might be a little longer than Mr. Potts' sentence,
Yeah.
just for planning purposes.
Are you guys ready?
I'm ready, yes, Your Honor. Mr.
Okay.
Gaines?
I am not.
Okay, well, take your time.
I will need a few minutes once I.
We're just trying to kind of figure out what it is, and then maybe we'll do the
If you
sentence.
need me to fill some time, Your Honor, that's fine. I'm ready now.
Don't feel rushed.
Yeah, I need to get my hands on 2 agreements, send them back in a few minutes.
No problem. Take your time.
Thank you.
Mr. Gates. Come on.
Yes, we need a max pressure.
Works for me. Your Honor, this is Mr. Elijah Westbrooks before the court in 23 CF 1148.
Very good.
Yes, Your Honor, this time we're going to enter a not guilty plea in Mr. Westbrook's case. I don't know that the state has filed that information in this case yet.
They have not filed it. We should continue the arraignment.
And that was my thought as soon as I said that, Your Honor. Well, the only reason I say is because there's a transfer now from Crestview, so there's probably this miscommunication.
You want me to give you a case number?
I have it, Your Honor.
So why don't we do this? Let's assume we don't have information. Let's continue this to the next arraignment.
In abundance of caution, Your Honor, I'll let the court know, once it's filed, I'm going to do not guilty plea anyway. So it may be easier just to put in for the 16th, and once they file the information, I'll go ahead and process the written plea not guilty.
Okay, so we'll continue to the next pre-trial at 8/16.
Yes, Your Honor.
And soon you'll file a not guilty plea when it comes across your desk.
Yes, Your Honor. As soon as I see the information, I'll file that written plea not guilty.
Okay, very good.
Michael Gallup.
You might have to know the information is not yet on file.
Yes, I appreciate it.
What's the name?
This is Michael Gallo, Your Honor,
Okay,
in
yeah.
cases 21 CF 2220 and 23 CF 954. At this time, we're going to enter a guilty plea in 23 CF 954 and a denial of the violation of probation 21 CF 2220. If we can move him to the August 14th or August 16th pretrial at 9 a.m. My expectation is we're going to probably enter a plea or sooner and ask for sentencing, depending on how things go with treatment.
Very good. The court will enter the not guilty and denial on the VOP and reschedule both of these hearings, continuing to the pre-trial on 8/16 and 9 a.m.
Thank you, Your Honor.
Thank you.
Caleb Gordon.
Your Honor, this is going to be Mr. Caleb Gordon in front of the court in 22 CF 41, 22 CF 10, 23 CF 1062. At this time, we're going to enter a not guilty plea in 23 CF 1062 and a denial in the 2 BOP cases. The state and I are close to an agreement. They need to reach out to the victim to give approval. If we can bring him back either Monday or Tuesday, my expectation will be it'll be a plea at that time.
What do we have on Tuesday now?
That is your plea day, okay.
We have Dr. Day on Monday and then Tuesday.
So far you have 33 on your arraignments for miscellaneous criminal, that's your DOP
We have,
evidence.
you have in the morning? That's in the morning?
Yes, sir, and then you have 19 on your plea day, and in the afternoon you have 5 longer hearings.
Let's do it in the morning on the 20th.
Thank you, Your Honor.
That'll be June 20th, is that right?
Yes, sir.
9 a.m.
Thank you, Your Honor.
Gage Hall.
Your Honor, this is Mr. Hall before the court on 23 CF 107. We have a plea agreement to be filed in his case. The state is signed the plea agreement. I do want to let probation know that Mr. Hall does have a violation of probation pending in Leon County, so he will not be released. They'll need to get information he can take before he goes.
Thank you.
And for the state, I also just put a pin in the thought on this, Your Honor. If Mr. Hall goes to Leon County and ends up with an incarcerated sentence, my intent is to bring him back and to try and do a modification so that it's just an incarcerated sentence to cover both counties. I was going to say with no objection to that. If he ends up getting a DOC sentence there, going back and doing a current sentence.
We haven't talked about that before, but I wouldn't have an objection.
Mayor Coach, Your Honor?
No.
Thank you, Your Honor.
Your Honor, this is not a downward departure. He does not swear.
Very good. You announced the plea, Mr. Gibbs.
Yes, Your Honor, if I can let him take a look at the score sheet real quick.
Sure.
Yes, Your Honor. Mr. Hall will be entering a plea of no contest as charged to be adjudicated guilty in both counts. We're going to do 3 months in county jail concurrent with credit for all time served. And I put count 2 in, Your Honor. It actually should be count 1. That's the felony count. It'll be 11 months, 29 days of probation. I have that same court cost that I got earlier on the DUI, so I'll just say standard court cost, $150 offender fee, $2,000 fine, substance abuse evaluation within 30 days of release, and record and treatment within 60 days of release, random urinalysis, 50 hours community service work. Defendants asked to buy out the community service work at the same rate. Victim impact panel, multi-offender DUI school, 5-year driver's license revocation, 2-year ignition interlock device, and then, as I said, Mr. Hall has a hold from Leon County for BOP, and this will, he understands that this will be part of that violation proceeding.
Point of clarification, the 2-year ignition interlock, is that 2 years? I assume that's 2 years after he's eligible for get his license back. So for 5 years and then 2.
The way that I understand it, Your Honor, is on any vehicle registered in his name, he has to have the ignition interlock, whether he uses the vehicle or not.
Okay, so that's during his term as I'm just wondering why you have an interlock if you have if your license doesn't.
Yes, sir. It's essentially a
like having a GPS monitor for traffic.
It is, Your Honor. It's essentially the way that it was always explained to me was that it's attached to the license. In order to get his license back, he's got to show proof that he's had that permission in or out for the 2 years.
Okay. Okay. And you want to go ahead and put the standard court costs or whatever, however you change it, or anything?
Yes, Your Honor.
So state an agreement on this, please.
We are, Your Honor.
And the reason I did the probation on count 1 versus count 2, Your Honor, is because of the jurisdiction issues pretty much still on the probation follow.
Right.
It was easier and cleaner to do that on count 1. What is the court cost for standard DUI or DUI?
Well, I heard you mention a $2,000 fine. Okay, it's going to be the $438 court cost, then a $100 surcharge, and then there will be an additional $515 on every WLSR.
Okay. So essentially, an additional roughly about $1,100 for standard cost on that. Any approach with that change, Your Honor?
Mr. Hall, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So you heard your attorney state the terms of the plea agreement, and those terms are also contained in the written plea agreement that I see you signed. First question, did you read this plea agreement closely?
Yes, sir.
And did you go over it in detail with your attorney, make sure you understand all the legal ins and outs of this agreement?
Yes, sir.
Understand waiving the right to go to a trial and waiving some other valuable legal rights as well. You've gone over all that with your attorney?
Yes, sir.
You believe it's in your best interest to enter into this plea here today?
Yes, sir.
No recourse to get you to enter into it?
Yes, sir.
Okay. Based upon that, the court will accept your plea. There'll be an adjudication of guilt on both counts. There'll be 3 months county jail concurrent with credit for all time served. In totality, that's, okay, you confused me. We've got 3 months county jail on both counts.
Yes, sir.
Concurrent. And then in count 2,
should be count 1.
In count 1, it's 11 months, 20, so that's in addition to the 3, you're doing
Yes, sir.
11, 21, 29, okay.
Followed by?
Yes, Your Honor, and as I said, the reason I did it that way is because the misdemeanor, if we did 3 months followed by a year, would be over the jurisdiction
Right,
period.
right,
So
right.
I did it as clean as we did count 1, which is the felony count.
In addition to that, you've got the substance abuse evaluation, random UAs, recommended treatment, community service hours, buyout of community service, number of other things, DUI school, all these things are contained in. You've gone over all this with your attorney, have the fees and costs that are contained in here. Okay. And those all obviously have to be paid while you're on probation. Okay, any questions regarding this? Thank you very much.
You know, this next would be.
Sir, you have 30 days to appeal this. I got to tell you.
Yeah, next up that is going to be Jonathan Hodge. We do have a plea agreement that he filed in Mr. Hodge's case, Your Honor. He's currently signing the plea agreement. approach with the copy of the plea agreement?
Yes, sir. You announced the plea.
What was striking from the victims?
If I can, Your Honor, real quick, this working the score sheet, Your Honor, out, there was an error that Mr. Lasco and I discussed that gets Mr. Hodge under 44 points so we can do this plea agreement. Mr. Hodge will be entering a plea of no contest as charged in 23 CF 1034. The adjudication of guilt in all counts will be sentenced to time served, no probation followed. 615 courthouse, $150 defender fee. Mr. Hodge would ask for 24 months from the date of release to have those outstanding costs paid. Just for the record, the reason the state agreed to time served was that Mr. Hodge was sentenced to DOC in our health court, and they were inclined to not extend that stay by this plea agreement. May I approach this court sheet?
Stating agreement?
Yes, Your Honor.
Mr. Hodge, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so you heard your attorney state the terms of the plea agreement?
Yes, sir.
And that's contained in the written plea agreement as well. Have you read through this plea agreement closely? Did you go over it with your attorney in detail?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving the right to go to a trial and waiving some other valuable rights. You believe that's in your best interest to resolve it all today?
Absolutely.
You have had all your legal questions answered?
Very much.
Okay. Based upon that, the court will accept your plea here today. There'll be an adjudication of guilt on all 3 counts. You'll get credit for time served on all 3 counts with no probation to follow. Got the court costs and fees. You do have 24 months from the date of release, from your DOC release, because that is a DOC in another case, Department of Corrections sentence. So when you get out of that, when you get out from DOC, you'll have 24 months to pay the outstanding court costs, and then it'll go to collections. Okay?
Yes, sir.
Any questions?
No.
Thank you, sir.
Thank you. Your fingerprints, Mr. Hodge.
Thank you, Your Honor. That's all I have before the court today.
That's all you got today?
Yes, Your Honor.
I've got some other ones here. Have your name on it.
If I have more, I will stay, Your Honor.
Your Honor, have you?
You want me to name them out, please?
Yes, Your Honor. I can tell you where we're
One
at.
is Andrew Holster.
Written plea not guilty.
Okay. So we're coming back on 8/16 on that?
8/14, Your Honor. He bonded out.
Like I said, 8/14. And then I saw there was another one here that we passed over. You probably had one in as well. Marcus Andrew Fennell.
Written plea not guilty, Your Honor.
Okay. I guess you're good to go. Now, we do have one more case with Mr. Harper. Let's see what they've got. TJ?
Mr. Kendrick here, no, it says he doesn't have an attorney, is he?
Yeah.
Kendrick?
Kendrick, yes, that's a no attorney. He's written.
Okay, thank you.
Mr. Kendrick, this is case number 2023 CF 948. We're here on, obviously, plea day here today. In a second, I think the state have anything they want to offer at this point?
Yes, Your Honor. The state would offer an adjudication of guilt, 2 years of regular probation. He would have $615 in court costs. During probation, he would be subject to random urinary analysis. he would have to complete a substance abuse evaluation and complete any follow-up treatment that's recommended. And then he also needs to maintain employment. If he's not employed, he needs to be doing 3 to 4 applications a week.
Okay. So Mr. Kendrick, that's kind of a long, complicated offer that the state made. You do have a right to have an attorney appointed. We can do one of two things here today. If you wish, I'll appoint you an attorney.
I'm fine with that. All I ask is, I have a misdemeanor DUI. Do you run at CC with it?
Say that again?
DUI and a misdemeanor. Will you run it concurrent with this?
I'm not aware of any DUI, so.
I'm not familiar with that. Have you pled in that?
No.
So I'm not willing to resolve the DUI today because I have no knowledge of the facts.
Yeah.
He's not represented by counsel in that case either. He's set for July 31st with Judge Stockford.
I would suggest we just enter a plea here today, enter a not guilty plea. Get an attorney.
I don't need an attorney. I'll plead guilty to it.
Can I ask a question, Your Honor?
Yes.
Are they stemming from the same instance? Like, did you pick up both charges on the same day?
No.
Okay.
One was in April and one was May 23rd. I caught this one first.
Why don't we do this? I'm gonna enter a not guilty plea on your behalf. We're gonna come back here on 8/16 at 9 o'clock. That's at the pretrial. In the interim, you're gonna have to plea on your other case. We'll give the state an opportunity to figure out whether they can do what you're asking. The problem they've got is they don't know anything about the other case, and they're not gonna time together.
Well,
not knowing anything about the other case.
Well, don't time together. I'll just plead out to this and then worry about that later. Then.
Okay. So you want to accept their plea they're offering?
Yeah.
Can you put it in writing for me?
I can, Your Honor, if the public defender would be so kind as to give me a blank form. Or
can you give Mr. Lasco plea form?
Okay. I want to put Kendrick back in there. He needs to come back out later.
We'll get it squared away today.
So remember Atkins and Allen. We'll do the female first. Yes, sir.
And Your Honor, just so the court's aware, in that traffic case he's got, the application was not complete because he didn't sign it. So the clerk didn't file him no determination.
Let's see what the state, Lisa's taking in part. Would you check on whether there's a sufficient plea on still Mr. Harper's case?
There's a not guilty plea, yes, sir, that was entered.
Okay, that's fine. And it's set for 8/14, 8/16.
Where are you?
Right here, man. Right here, man. Right
Yeah. I have a not guilty plea.
Yeah, sure. It looks like Mr. Harper's withdrawing from Mr. B's case because he's got representation of Mr. Schaffner. He filed a written plea not guilty both, and then filed a motion to withdraw in Mr. Lee's case.
Very good. We don't have to take any action.
Your Honor, Steve Medina with Carson Ray Allen in 22 CF 2031. Ms. Allen is signing a plea and sentence agreement that we have reached with the state.
Yes, sir. Yes, sir.
if I may approach, I actually need to just make sure she's seen the score sheet. Mayor, Coach Judge. I have a copy for probation. Your Honor, under this agreement, Carson Ray Allen will be resolving her case for the withhold adjudication, and this was on a 2022 battery upon an EMS person involved in responding to a 911 call. I've advised her that I don't know if this is the best deal that's possible if she were to fight the case, but she wants to take the case, to take this resolution to get out of jail. I've also advised her that we have a motion for bond hearing today set, and she can pursue that and see how that turns out. But she believes it's in her best interest to go ahead and take this deal with a withhold adjudication. She represents to me she's never been to prison, is not a convicted felon, but if she gets in trouble, she can become a convicted felon through this. So I hope she, 24 months probation, court costs, I'm not sure exactly what those are, Madam Clerk. Battery upon an EMS court costs, can you advise?
Yes, sir. Is it remaining a felony?
Yes, ma'am.
It'll be the 515 with an additional 201 and 151 and your public defender fee.
Okay, so
I think
it's
that's 976.
plus
Do
150.
you want the $100 FDLE?
I don't want it, but it's a matter of whatever the
It's
state
optional.
or the statute requires.
The state always asks for the $100 FDLE.
And thank you, Madam. Your Honor, there will be mental health evaluation within 30 days with any recommended treatment to commence within 60 days. The state basically wants her to do anger management, but the way it was written up, by the way, there's 24 hours community service. But on anger management, I wrote it up the way the state had it in the agreement, was to get an evaluation for anger management first within 60 days, with any recommended treatment to commence within, it should be within 90 days. Can I change that to 90? Sure. May I just start that?
You also need to put the correct court costs and stuff.
Okay, yes, sir. Is that, Madam Clerk, did you say that was then about $1,000 or so?
It's going to be 976 on the cost and then your 150 PD.
Okay, yes, Your Honor. So I'm writing in 976. You understand that? The court costs are going to be 976. And then it's going to be 9 days to that should be a 9.
90 days to pay
Okay.
976.
No, ma'am.
Okay.
So you're welcome. I'll give you my copy.
Okay.
Sorry, Your Honor.
Thank you.
Thank you. So just continuing. The state would be agreeing not to file charges on the FTA.
Okay, very good. Is that the agreement from the state?
That is the state's agreement, Your Honor.
Okay. Ms. Allen, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay, you heard your attorney state the terms of your plea agreement,
Yes.
and those same terms are contained in the written plea agreement. Did you, which you have signed, did you read this plea agreement closely?
I did.
Okay. And have you gone over the plea agreement in detail with your attorney, made sure you had all your legal questions answered?
Yes, we spoke about it.
I'm sorry?
We spoke about it.
Okay. And did you get all your legal questions answered?
Yes.
You sure?
Yes.
There's a slight hesitation
No.
there. Okay. Just want to make sure you understand what you're doing here. That's all. You don't want nobody trying to push you into something. Want to be clear.
Yes,
Okay?
sir.
So you do understand that by entering into this plea agreement here today, it's the final resolution of your case, and you're waiving the right to go to a trial. This will today. You understand that?
Yes, sir.
You're entering into this voluntarily.
Yes, sir.
Very good. Based upon that, the court will accept your plea. Court will withhold adjudication on your charge, sentence you to 24 months probation. There are the court costs that are contained in the plea agreement. Mental health evaluation, 30 days to commence in 60, and 24 hours community service. Anger management evaluation within 60 days, and starting recommended treatment in 90 days. State will not pursue any charge for failure to appeal. Any questions?
No, sir.
Thank you very much.
And Your Honor, she'll need to report by 8 a.m. tomorrow at 13 Kelly Avenue, Fort Walton Beach for your
You
probation.
do have 30 days to appeal this sentence.
30 days to appeal, can you explain that to me?
Yeah. Even though you just entered into this agreement, you can still appeal. Makes no sense. Well, I gotta tell you.
Okay, and then if I
I
appeal,
forget to say it
if
all
I,
the
if
time.
I had to appeal for some reason, then what would happen? I mean,
You appeal it. I don't know, you have to talk to your attorney about it.
okay.
Can't give you any legal advice.
Will I get a card with the address for your report to in the morning?
Yeah, we're gonna give you all that. They'll give you, I gotta get your fingerprint.
Okay, thank you.
No, there's no prints, Your Honor. Sir, it's a withhold.
It's a battery though, so.
Oh, you have to do the prints anymore? Yes, sir, thank you. Prints anymore. Thank you, sir. Thank you, Your Honor.
Thank you, Mr.
Should be coming up, Billy Dean Atkins.
Okay.
Hey, Ken, can you get
Yeah.
Atkins on the keys? Your Honor, Billy Dean Atkins is before the court 23 CF 970. He has signed his agreement that's been worked out with the state. Just want to make sure he's seen his score sheet. If I may approach, Your Honor?
You may.
And there's no probation on this one.
Thank you.
Your Honor, under this agreement, Your Honor, Billy Dean Atkins in a 23-9 CF 970 will be adjudicated guilty as charged on a felony petty theft. And just for background purposes, he recently pled out with Marty Noakes, Esquire, to a 42-month DOC sentence, and this is taking that into account. There will be a 12.1 months DOC with credit for all time served, and with the sentence to be served concurrently with the sentence in 17 CF 3457 et al. There were 3 or 4 other cases too, Your Honor. There will be court costs, Madam Clerk, I think it's $515 court costs on a felony petty theft.
Yes.
Your Honor, do I need to write that in?
Yes.
Thank you.
Is that the agreement with the state?
That is the state's agreement, Your Honor.
And 150 PD fees.
Thank you.
Thank you.
Mr. Atkins, would you raise your right hand? Do you swear or affirm the information you're about to provide this course of truth, nothing but the truth, so help you God?
Yes, sir.
You went through this, asked you these questions a couple days ago, maybe yesterday. You lost track of it this week.
Yes, sir.
So you heard the attorney state the terms of your plea agreement. They're contained in this written agreement you signed. Are you clear about the terms of this agreement, and have you asked all your legal questions you need to ask of your attorney as it relates to this, to the plea agreement here today?
Yes, sir.
You believe it's in your best interest to enter into this?
Yes, sir.
You're waiving the right to go to a trial to do a final adjudication of this case. Do you understand that?
Yes, sir.
Okay, very good. Based upon that, the court will accept your plea here today. There will be an adjudication of guilt. 12.1 months DOC. It'll be served concurrently, same time, with the sentence in 17 CF 3457. 515 court costs and PD fees, which will go to budget.
Thank you, Your Honor. Look, I gotta get your fingerprints. Is there anything on you? You say that?
Sir, you do have a right to appeal in 30 days. Confuse everybody.
I agree to. I'm sorry, Your Honor.
That's right, go ahead.
I'm going to step outside with this gentleman for a moment and make sure all his questions are answered now.
We have Mr. Costello.
We do, yeah, right here. Actually, this is Mr. Bayshore, or is he not Mr. Lees? Oh, yes, the state has an announcement on that one.
Okay.
The state filed a no prosecution earlier this afternoon, Your Honor.
Okay, what's the name, please?
So I advised
This
him.
is Bayshore 23 CF 952.
Yes, Your Honor.
Okay. State's announced null process. Dismissed.
Thank you, Your Honor.
Thank you very much.
Thank you, Your Honor. And yes, I do have the Costello plea. He is unrepresented.
After we do this, Mr. Henderson will do yours. I haven't forgotten about you. We're running late here today. I understand.
Alberto Castillo Rodriguez.
How do you pronounce your last name, sir?
Castillo.
Castillo. So, Mr. Castillo, you've been charged in case number 23 CF 1066. Is the state willing to make an offer?
Your Honor, he's been charged in 23 CF 1066 with possession of stolen identification, failure to have required insurance, no valid driver's license, and no registration. His offer today is a 10-month pretrial intervention with a plea with 515 court costs, $100 cost of prosecution, surrender fictitious license, show proof of valid license, random UAs. If he wants us to draft this up, we can always pass this to 6-1.
So, Ms. Castillo, you do have a right to have an attorney appointed. I don't know if you understood all that she was talking pretty fast, all those things in that plea agreement. What we normally would do on this, enter a not guilty plea and appoint an attorney, give you a chance to go over it with your attorney, figure out whether you want to accept their plea. If not, you can figure out what to do with it, okay? Okay? Court will appoint the public defender. You do have to fill out an application form.
I did.
Oh, you did? Good.
Okay, well, let me just see if
Is it up here today, probably?
I don't know if anybody else.
When did you fill out your application?
Like 2 weeks ago.
Oh, really?
They sent me the letter, but with the wrong letter.
They send you what?
They sent me a letter. The envelope was in my name, but the letter it was wrong. The guy with the same last name, Castillo.
I do not show that indigency application has been filed in the case, so if we can give you another one, I don't know what they sent to him.
Why don't we do that?
Do you have another case that it would have been filed in?
I put out a letter like 2 weeks ago.
Okay, so we're going to give that back to you and ask you to fill, sorry, make you fill it out again.
Okay.
I'm going to go ahead, I'm going to assume that it's filled out, so I'm going to appoint you public defender, enter a not guilty plea on your behalf, and we'll come back on 8/16.
Okay.
Okay?
Thank you.
Thank you.
Excuse me, sir. Let me just hand you this card, okay? Thank you, sir. I'll come to see
We
you.
do one of the 230 cases real quick. Mr. Henderson, do we have Evelano?
Yes. We're ready to
Come on,
go.
Mr. Henderson.
Embolano.
Mr. Henderson,
Good afternoon.
please announce the case.
Yes. Tony Henderson from Martin, Arraignments.
And we're here today on motion to set bond.
That's correct, Judge. Previously, my client was released on bond on this case. While out on bond, he picked up a new law offense, DUI. That offense is still pending at this time. At that point in time, his bond on this case was revoked, and we're asking the court to set bond. At this present time, he's been in jail 79 days, I believe, in my calculations, and I'd like to call his wife as a witness.
What is the amount of the, did he have a bond on it earlier before he got no bond?
Yes.
What was that?
It was $31,000, Your Honor.
So you want to take testimony on?
Yes, Your Honor. I'd like to call his wife, Mrs. Arnold.
Okay.
We had the Castillo guy that just went back there.
What is her name?
When you get to the top of her name, Sandy, raise your right hand and face the court.
Ma'am, do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Please be seated. Counsel, you may inquire.
Ma'am, would you state your name, please?
Liz Ariano.
Okay. And, ma'am, how do you know Martin Arraignments?
He's my husband.
And how long have y'all lived in this area, ma'am?
We've lived here since December of 2017.
And do you have any children?
We do.
How many children do you have?
2.
And prior to being arrested, was your husband working?
Yes, he was.
And where was he working?
He was working at the track amusement park in Destin.
Okay. And how long had he worked there?
Just for a couple months. He had just gotten out of the military in September of last year.
Are there representatives of that work job here today?
Yes, they are.
And they're here in support of him?
Yes, definitely.
Okay. Ma'am, since your husband's been arrested or been held without bond, what type of hardship has that caused you and the family?
Tremendous. We have no family here. So, Terrance, he's all we got. We have no cousins, nothing. I'm a child protective investigator, so I work a really hard job, and that's brought a really big toll on me. I can't work long hours because I have no one to take care of my son. Last week I had to ask my 17-year-old daughter to take time off her work because I had a death case and had to work late. So it's hard to find any support. He's all I've ever counted on ever since we've been married. So obviously financially I cannot even, we're really running low on our savings, and if he doesn't come out soon and able to get his job back, and that's going to put us in a really hard place.
Are you requesting that the court set a reasonable bond today?
Yes, please, because he had to miss our son's birthday, our daughter's high school graduation. I mean, it's hard on my kids. I know it sounds stupid, but my son doesn't even believe in God anymore because he asks God every night to bring Dad home when he's not home. It's brought a lot of hardship all around in our house because, like I said, we have no one here. And he's all I can count on. He's all my kids count on.
Thank you, ma'am. I don't have any further questions.
Hold on, ma'am.
Yeah.
Hold on. State wish to cross?
We have no questions for this witness,
Maybe you
Your
step
Honor.
in. Thank
No other witnesses, Judge, just argument.
you. State have any minutes?
No witnesses, just argument, Your Honor.
You wish to make any final arguments, Mr. Henderson?
Yes, Your Honor. Judge, under the statute, it's clear he can be held without bond with a new law violation. To distinguish just a little bit, the new charge is a DUI, and normally people don't go out with the intent to commit DUI. It's referred to a lot of times as a crime of degree if you drink too much or you get into a circumstance and you make a bad decision to drive. Different than someone who wants to go in and break into someone's house or goes in and to a store and decides that they're going to steal something or something like that where they form that prerequisite. He has been in 79 days. It's caused some hardship. My clients learned this lesson, and all candor of the court, the case is ready for trial. All the depositions have been completed, and all the discoveries.
This case is ready for trial?
Yes. All
Are
that
we scheduled for trial?
we were going to address that today because the pre-trial, the plea date was yesterday. I asked him to pass it to today, so we could address that issue. But we would ask that the court set him on this move on.
Ms. Salmon.
Your Honor, I would note that the defense did say under statute it's clear he can be held without bond, and that's what the state is asking for. As far as DUI not being an intent offense, that's interesting because he went in his car with a bourbon drink and admitted it was a bourbon drink in his car, so he did intend to commit a DUI, Your Honor, while he was out on bond on an aggravated assault in which he slammed his car into another car and pulled a gun on somebody else. And then he goes out drinking and driving. This man is a danger to the community, Your Honor. And if he's willing to go to trial, he wants to go to trial this cycle, the state will be willing and able to go to trial as well. And we would ask that he be held without bond until his trial. The state would also put on the record that we would revoke any offers if he's planning on going to trial today.
Judge, as far as my understanding, the only offer that's been made in this case is a guideline offer. Now, I don't know if, ma'am, I don't know if you're the prosecutor who I've been playing phone tag with, who originally had this case. I'm not sure.
We'll make a ruling on this, and then you all can, if you want to have any further discussions regarding the plea, you're welcome to do that. She's not going to, she'll talk to you afterwards and hold the plea open long enough to do that.
I will do that, Your Honor.
Okay. So, anything further?
Nothing further, Judge.
There are, both attorneys have stated clearly what is the law, that on violations of probation, you do not have a right to have a bond. We're all clear about that. I try and look at individual circumstances to determine whether or not it's appropriate to have a bond. I don't always know bond. A lot of judges do around these parts. I don't. However, when you have a serious criminal charge of a violent nature and then follow it up with another issue that puts people's lives in danger, not once but twice, both charges, the court would agree with the state and has not been proven guilty on these charges, but there is probable cause, and based upon that, the court's going to maintain the no bond at this point. Now, we have some, we've got some other cases that we are going to be handling here this afternoon. If you all want to have any further conversation with regards to the plea, not suggesting you should, you shouldn't. It's up to you all. But apparently there have been some serious negotiations. So
yes, I just wanted to know because I don't know if she's prosecuted because I did the devil's bypass. So
No, I'm filling in for Ms. Sharpless, but I am the felony supervisor, so I would be authorized to negotiate. If you want to give me a call tomorrow and we can leave him scheduled for docket day, we can probably work this out because I would need time to comply with Marcy's law.
That's acceptable, Judge.
Very good. So we will, courts denying the motion to set bond, and we'll reschedule this for docket day, which is next Monday, and we'll look at where things are at that time. We'll pick plea or trial.
Yes, sir.
Very good. Thank you, sir.
Thank you, Judge. That's all I have.
I'm sorry to make you wait so long.
That's okay.
that?
Clear trial.
Yeah, clear trial, that's what I heard.
Anybody got a hearing device that works? One just ran out of batteries in one. Who do you want next, Your Honor?
Who do we have?
I'm ready to go with my out of custody, Mr. Donkey, with a PTI, with a plea, Your Honor.
Very good.
So we have signed it. Everybody signed the appropriate places in the PTI agreement as well as in the plea. And I'm giving him the PTI paperwork. His brother is with him. He's going to help him get to the PTI officer by 8 o'clock tomorrow morning.
Okay.
And if I may approach with the agreement, which is a very simple one, that states that that he is to be to complete the pretrial intervention program. If he successfully completes PTI, the case will be dismissed. If he fails to successfully complete PTI, he will go directly to sentencing, and he knows the importance of successfully completing the program. May I approach?
Thank you.
And there does need to be a score sheet right now. I don't believe there are.
Okay, Mr. Danke, you're still under oath. I think I put you under oath earlier today,
Yes, sir.
didn't I? So, you heard your attorney state the terms of this. This is a pre-trial intervention.
Yes, sir.
Very clear. You're pleading here today, so there's a partial resolution of this case going on today.
Yes, sir.
You'll have to complete your pre-trial intervention, in which case your case will be dismissed.
Yes, sir.
But if not, you'll come back for sentencing. Do you understand that?
Yes, sir.
But you're not going to a trial, you're not going to a final hearing other than that. Okay? You understand? You believe that's in your best interest?
Yes, sir.
You've gone over it in detail with your attorney.
Yes, sir.
Very good. Based upon that, the court will accept your plea. And the court will order you, I am not really ordering you, but you're entering into the pretrial intervention program, after which, if it's successful, it will be dismissed. If not, it comes back for sentencing.
Thank you, Your Honor.
Thank you. Good luck.
We'll take care of that. That goes back, that goes to the PTI officer. She has to sign it and enter it in the system.
Thank you, Your Honor. My only other client that I'm trying to get resolved is this newly appointed gentleman, Carlos Castillo Rodriguez, has a PTI with a plea. I've written the plea agreement.
What about Jared Dawson?
I thought we handled him this morning.
Yes, Your Honor, we handled Mr. Dawson this morning. I believe he's coming back on docket day.
Okay, very good.
Is Christine back there?
Let's do this. And then I'll explain to you when I get another piece of paper.
Mr. Gates, you're finished.
Yes, Your Honor. I'm still working on the police thing for evidence office.
Mr. Romero, you're done with all your underlying cases.
I'll make you a star.
Plea cases today. Do you want to go ahead and read your sentence?
I've been for all of
See,
them.
but maybe
I've been here since
possible
last
return, Your Honor, unless one of the other state attorneys would be
Judge, I do have
I've streamed it.
one case that can go. It's my last case for the day.
Give me a card.
Mr. Kendrick just needs to sign his agreement.
Was that one that didn't have a return?
Just, my number's not. You got a pen with you?
Bring him out.
My number's not.
Yeah, there you go.
Mr. Kendrick, is that who you need?
Yes.
Yep. Now, if Judge Ketchell, Judge Brown, or Judge Terrance has a criminal felony day, I'll be there. You try to call, I don't answer, that's why. Please call me.
So this is the written agreement.
What's your name? Ken.
I want to be clear, I'm not your lawyer.
K-E-N.
I'm the lawyer of the state, so.
N-I-E-L-S-E-N.
Nielsen?
Yep. And the reason I don't put that on the card is because I hand these cards out to all the people in here.
So I'll go.
It's sort of, I don't really want to know that it's a 5 weeks.
2 years of probation, substance abuse evaluation, and a recommended treatment. You need to get that done within 30 days of your release. You have, if it's recommended that you have to do more treatment, you have 60 days to get that done. You have brain urinary analysis, and you need to maintain gainful employment. I know you mentioned that you're already employed.
Yeah, CV5.
Okay. And then it's going to be $650. All right. Any questions about this? Okay. So if you agree to that, those are the right terms, sign here and date here. Judge John, I need to review the score sheet with him.
Mainly whether he's incarcerated.
Oh, he doesn't score.
That's what he was to be explained.
Okay. So this is what's called your score sheet. It's essentially what's called a rap sheet. You're pleading to possession of a controlled substance. These are your priors. There's one manslaughter charge out of Alabama, and then there's 2 misdemeanors that are various misdemeanors that occurred in Florida. Does all this sound correct to you? All right.
How could you use that against me right there in Alabama? That thing has been 20 years ago. Happened in 2003.
Judge, I don't want to give him legal advice.
You're not giving him legal advice, just asking why it's on the score sheet.
Well, it stays on the score sheet and it's assigned, even if it happens in another state, it's still in the record, right?
I got you.
So it stays on, it's assigned, it's assigned a point value just like everything else, and then it's all added up. If you get to over 44 points or 44 points, then you automatically have to, you score DLC, right? But you don't score 44 points, you score 30. Does all that make sense?
I got you.
Thank you. Was there any explanations of that?
No, you're good. Good. Thank you. All right, Mr. Kendrick. I think I swore you in already, didn't I? Did I swear you in? Raise your right hand. Do you swear or affirm the information you're about to provide this court? It's the truth, nothing but the truth, so help you God.
Yes, sir.
So you look over the plea and sentencing, it says a sentence recommendation. It's really a plea agreement form. And you sign that, and the plea agreement itself is the adjudication of guilt. So you'll be adjudicated guilty of the charge, the possession of a controlled substance, substance abuse evaluation and treatment starting within 30 days, random UAs, maintain gainful employment at $615 in court costs. Okay, pretty straightforward.
Yes, sir.
Okay. So you understand that by entering into this plea agreement here today, you're waiving the right to go to a trial. Do you understand that?
Yes, sir.
You're limiting your right to go to appeal. No, I'm going to tell you got 30 days to appeal. It limits that. Confusing, but so I don't know why I keep saying that. Right? So, do you believe this is in your best interest to enter into this?
Yes.
Okay. Very good. Based upon your testimony, the court will accept your plea agreement, and the court will adjudicate you guilty of your charge, sentence you to 2 years probation, substance abuse evaluation and treatment, random UAs, maintain gainful employment, and the fees and costs. Fees and costs have to be paid during your probation.
Yes, sir.
Any questions?
No, sir.
Thank you.
Judge, I don't have anything else before you go.
You can go. Thank you.
Is this the one where you can't use this?
Okay.
I just don't know, it's not mine, so I don't know. These things are in trouble.
Thank you.
Steal those too.
Tomorrow? You up?
I didn't know if Ms. Boss had a preference on matter. She indicated that she might, the other matter might be lengthy. This one will be shorter, but whatever the court will do.
The other one will, I'm sure, be lengthy.
That would be this line.
So just tell me which inmate it is, and I'll bring
This
this.
is Mr. Darren Potts, right?
Potts.
Darren.
Correct.
I have them all as defendants.
For Mr. Potts.
Potts.
Look at that.
And Your Honor, as he's retrieving Mr. Potts, may I provide a score sheet to the court? And Mr. Morrow, just want to show it to you before I take it up there.
Objection, Your Honor.
Thank you very much. Okay, we're here today on the sentencing for the proper case number.
14 CF 1480, Your Honor, the case is BOP, having previously entered the plea straight to the court on the violation.
Very good. So,
the state has...
Before you call any witnesses, if you wish, you may make an opening statement or just proceed to...
Very briefly, Your Honor, the state's presented me with their score sheet. We've got no objection to the score sheet, but I can provide with that. The state has also previously stipulated to the admissibility of Dr. Zeman's report. I have prepared a copy for the clerk. It's previously marked as Defendant's Exhibit 1. May I approach the clerk?
And that is accurate, Your Honor. The state is not objecting to that. Court taking that into consideration.
The psychologically evaluated?
Yes, Your Honor.
Okay.
Did the court have an opportunity to review my very brief sentencing memorandum?
I did.
Excellent. The only thing I might say about that is since the filing of the memorandum, I spoke to Mr. Potts, he's going to make the election not testify today, so there won't be any testimony. The only evidence would be the affidavit that's already in the file, and then also the evaluation that's been provided.
Hold on just a second. Hold on just a second. Mr. Morrow, you may make any opening remarks.
Certainly, Your Honor. Thank you. We're asking the court to consider reinstating Mr. Potts' probation. Per the statute, the court always has the discretion to reinstate should they see fit. For the court's awareness, his current termination date, if the court were to reinstate, is currently scheduled for 8/11/2025, so he still does have time left on probation. It's the position of the defense. We are before the court with no new law violations. We are not here with any positive urinalysis or allegations of drug abuse. We're not here with any allegations of failure to report. It's the position of the defense that, coupled with the technical nature of the violations, as well as the issues exhibited in the report provided by the defense expert, Dr. Zeman, that this doesn't so much represent a willful and substantial violation, despite the fact that we have admitted to that. We're asking the court to consider this still a candidate for supervision based on the nature of the violation, and consider reinstating Mr. Potts' probation, because he does still have time, he does still have an ability to show the court that he can comply. Now, if the court is not inclined to reinstate Mr. Potts' probation, we believe that the evaluation provides the court with the discretion necessary to downward depart from the lowest permissible prison sentence presented by the score sheet. and either sentence him to time served or a county jail sentence. It is the position of the defense that this particular violation, that we are admitting it, is not deserving of the imposition of the 10-year suspended prison sentence. We do believe that the court will have discretion down in their part if the court is not inclined to reinstate due to the mental health issues that's evidenced in the report, those being ADHD, PTSD, and mood disorder unspecified, all being mental health disorders requiring specialized treatment. And I just want to read one passage directly from the evaluation. It's found about halfway through the last paragraph. With respect to Mr. Potts' psychiatric, this is quoting directly from Dr. Zeman, Your Honor, in that last paragraph. With respect to Mr. Potts' psychiatric treatment needs, it is possible that he receive medication management and individual psychotherapy at the Bridgeway Center for locations in Crestview and Fort Walton Beach. In the final disposition of this case, the court may wish to consider as mitigation, Mr. Potts requiring specialized treatment for the mental health disorders that are unrelated to substance abuse, addiction, or any physical disability, and that he is amenable to treatment. He expressed recognition and accept responsibility for his violations, and his re-entry into society has been quite challenging. He was still a juvenile in terms of brain development at the time of his arrest and incarceration, and experienced exposure to multiple violent and other traumatic events during his incarceration. His history of mood dysregulation, as well as poor impulse control, is well documented. His incarceration occurred during a period of neuroanatomical and personal maturation, resulting in a stunting of development. And the defense agrees with that, Your Honor. We're asking the court to take all of these things into consideration, specifically, and I think most importantly, the nature of the violations, and put together with what we see in the expert's evaluation. We believe that he is a candidate for reinstatement. We're asking the court to allow the last, since November of last year, Your Honor, my file reflects 11/22 incarceration, about the last 7 months, to serve as a sanction and reinstate him to supervision, Your Honor.
Ms. Paulson.
Your Honor, the defendant was originally sentenced for lewd lascivious conduct to 78.3 months in the Department of Corrections, followed by 5 years of sex offender probation. He did serve the DOC time and was placed on probation. He did have a violation back in 2021. At that time, he was given the opportunity, instead of what he was scored out to go back to DOC, he was given the opportunity to continue community-based supervision. So he was given a break by the court at that point. Instead of taking advantage of that, as part of that sentence, he was also given a 10-year suspended DOC sentence. He's basically telling the court, I can make it in the community, but if I can't, if I chose not to follow the rules, then please send me back to prison, because that's what I'm agreeing to. Your Honor, these violations that he's here for now are willful and substantial, especially given the nature of what he's on probation for. He was placed on a GPS monitor so that we could better track him. He's a sex offender. We have to know where he is to protect the community. He violated that on numerous occasions. And then he lied about it to his probation officer. He was found where children congregate, in a park where children congregate. Again, placing the children of this community in danger. Given the nature of his charges, that is substantial. Additionally, Your Honor, he violated his curfew on numerous occasions and misled Ms. Rose, his probation officer, as to why or where he was or why he was missing that. It's all spelled out in her probation violation report. That is also substantial, because a curfew, again, it gets us some control over where a sex offender is and what they're possibly doing. Finally, his other violations, I believe, were the fact that he did not participate in sex offender treatment. Again, substantial, Your Honor, given the nature of the charges. That is something that is required by statute, that he participate in sex offender evaluation and counseling, that he get the treatment for the charges that he's in for, so that hopefully he will present less of a danger to society. Yet, Your Honor, each one of these are basically violations that are being based on choices that the defendant is making, and those choices are not related to the disorders that the defense is claiming that he suffers from. And I'll go into that in a moment.
Your Honor, we believe he was given the chance to show that he can make it on community-based supervision. We are asking the court to impose the 10 years DOC that Mr. Potts told this court he would take if he could not follow the court's orders. And he has not done so based on the violations that Ms. Rose presented to the court. Your Honor, as the court knows, he does score out, to 89.6 points minimum, which is 46.55 months state prison as a minimum guideline sentence. For the courts to depart even below that, the court must find that there is a legal basis for departure and that it is appropriate to do so. We do not believe that the defense has established a legal basis for downward departure. We believe that the report by Dr. Zeman should not be considered as substantial competent evidence in that, Your Honor, Dr. Zeman met with the defendant for 45 minutes. He did not perform any tests. He did not review any medical records or any mental health records. He only looked at the records that the jail had. And as the court is well aware, the jail does not engage in extensive mental health evaluations or treatment. So he had a very limited record, if any, that he reviewed. His diagnosis is based merely on a 45-minute interview with Mr. Potts and a letter, I believe, that was provided by a family member that indicated he had a history of mental health disorders, yet there is no other records that support that. So we don't believe that that is competent, substantial evidence upon which to make a finding that he suffers from a mental health disorder. Your Honor, we also believe that he hasn't met the guidelines as far as any specialized treatment that might be needed. There is a vague reference to what kind of treatment he might be able to benefit from, but it doesn't show that it's specialized. That is available, unfortunately, it's almost a mainstream that is available these days because many people do suffer from PTSD or mood disorders. So it's not really a specialized treatment that Dr. Zeman has laid out that Mr. Potts needs. And finally, Your Honor, as the court is aware, in order to downward depart for that particular basis, the court has to make a finding that he does suffer from a mental health disorder not related to substance abuse, and that he's amenable to treatment. But amenable does not mean he's willing to engage in treatment. It means that there's a substantial likelihood that if he engages in that treatment, that his behavior will change. That's the standard that the court is required to use for amenable. These violations are choices that the defendant has made that are not related to a mood disorder, to PTSD, or to ADHD. These are choices he has made to willfully not comply with the court's order, not going to sex offender treatment, not being there for his curfew, not being within the guidelines of his GPS, being where children congregate. Again, all choices not related. There is not a substantial likelihood that that behavior will change with any kind of counseling or treatment as Dr. Zeman laid out. So we do not believe that he's amenable to treatment. But even, Your Honor, if the court disagrees with the state's position and finds that we have established a legal basis, we do not believe that he meets the second prong of the test, which is appropriate to downward. We do not believe that the second prong of the test would be met. Legal basis and is it appropriate? We do not believe it's appropriate because Mr. Potts was given the opportunity to show that he can make it on community-based supervision. The first violation, the court did not send him back. It gave him a suspended sentence instead. He knew he had that hanging over his head, yet on numerous occasions, he chose to violate. It wasn't a single isolated violation, it was an accidental violation. These were willful choices, and all of them are substantial, especially given the nature of the charges that Mr. Potts is on supervision for. We're asking the court to impose the suspended 10-year sentence and keep the community safe from Mr. Potts. Thank you.
Madam Mayor. briefly in response to some of the things the state said, Your Honor, we don't agree that Dr. Zeman's report doesn't represent competent and substantial evidence. He's a licensed psychologist that our office regularly uses, accepts JAC rates, and I use Dr. Zeman in his reports in court many times. So I don't agree that this report doesn't represent competence and substantial evidence. We also disagree that we haven't shown by a preponderance that the court does have grounds to downward depart based on Mr. Potts's mental health issues and remedial treatment. We also disagree with the state's position that he's not amenable, and I understand what Ms. Bosso is saying about the definition of amenability, but we think that Mr. Potts is amenable to the treatment, and we do think that he would benefit from the treatment. We would again suggest to the court that these violations, while serious because of the type of supervision that he is on, they still represent technical violations, and that he should be given another chance, Your Honor. He's been essentially incarcerated since he was 16 years old. He lacks maturity and sophistication, and we do think that he should be given another chance at supervision, Your Honor. We are asking the court to reinstate the supervision, but again, it's the position of defense that we have shown by a preponderance of the evidence that the court can and should downward depart based on his mental health issues not related to substance abuse and his amenability to treatment, Your Honor.
Okay. Court's going to take a short recess, and we'll come back and we'll make a court will make a rule. Take a short recess.
All rise, please.
Have a seat. You don't have a seat right there at your table. I know how to say it. And I'll tell you
for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured,
family-owned and operated with 24 years of local service. We specialize in shingles and metal, re-roof, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Prech Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview.
We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Prech Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning. So come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Pratch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
It's Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestvew's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestvew's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service.
Court, after due consideration would make a couple of findings. I believe that the psychological evaluation is competent and substantial evidence. However, it's not persuasive evidence in the court's view. And I think it does not meet the standard for the requirements that the counseling or whatever would be, that the defendant would be amenable. I believe that there was not information placed in the confidential evaluation. And quite frankly, I was surprised by the fact that there were no prior medical records that are contained in here. I don't know how he comes to some of the conclusions he does based on it. These were serious charges to begin with. He was allowed the opportunity to get out on probation and must have understood that this 10-year suspended sentence was extremely serious. He did not appear to take the probation seriously in multiple substantial violations. Although they may have been even technical in nature, they were substantial and tied directly to the charges. Therefore, the court's granting the state's request for the suspended sentence to be lifted and to sentence the defendant 10 years. Credit for time served. Anything else the court needs to do at this time?
No, just probation will be terminated then.
Correct.
Court advised Mr. Potts as to his appellate rights, and we'll go from there.
Mr. Potts, you do have a right to appeal this sentence within 30 days. Okay? Do you have any regarding that you need to talk to your attorney right away because you're on a short time? Okay? Thank you very much.
Oh, yeah.
I'm still delving into the case. I need an adjudication, Your Honor.
Yeah.
Okay.
There's an adjudication of guilt in this case, but what's the reason for that?
Right this way, Mr. Potts. Could you get Mr. Castillo Rodriguez? I think it's Castillo Rodriguez.
Your Honor, I believe that's all I have this evening. Maybe excuse me. I want to get out in front of something in the rush to get some matters moved. I think I may have double booked myself in front of Your Honor here around on the 22nd. I may need to file for continuance on some of those matters. I just wanted to get important matters.
Okay, we'll work around it as well, so don't.
Okay, well, then I won't file anything just yet.
We generally, I mean, we wait all the time on.
Okay. I just didn't want to slow things down unnecessarily. No, it's not a lot of matters.
We'll work with it. We'll try and we understand if you're in two places, and we'll work with you.
Okay, I
So
just want to
try and do it. If you can't, and if you have to change it, that's.
It's not something I'm used to because I'm not used to one or two judges. I just want to let the court know.
Yeah, one more question for you.
Right. You just let the attorney know.
This guy's
I'm trying to wrap everything up.
Plea now and then we have one last one.
This next time. Thanks, guys.
Mr. Medina, or do we need anything else?
He's confirming probation, Your Honor.
Just, Your Honor, I'm making sure that for Mr. Carlos Alberto Castillo Rodriguez, that probation has a copy of the PTI agreement, just in case he were to lose it at the jail tonight.
Very good.
Your Honor, Steve Medina with Carlos Alberto Castillo Rodriguez in 23 CF 1066. I have been over a plea and sentence agreement with him that is a very simple cross-referencing plea agreement to a PTI agreement that the state has signed and that Mr. Carlos Alberto Castillo Rodriguez is signing. And he'll be, to my knowledge, he doesn't have a hold on him, and he'll be, when he gets out of custody, he has to immediately report to Fort Walton Beach. I think it's 13 Kelly Avenue, and he'll be given a piece of paper to show where to go. But he's going to take custody of the PTI agreement. The plea and sentencing agreement, if I may approach with that, Your Honor. Just making a photograph for myself. May I approach that? And we do not need a score sheet at this time, I believe.
Thank you.
Under the very simple agreement, it'll be defendant will successfully complete pretrial intervention. If he successfully completes PTI, the case will be dismissed. If he fails, I failed to complete writing. I got distracted with something running down the hall, Judge. I'm so sorry.
That's all right. You can finish that sentence.
Yes, mid-sentence.
Mid-word.
Mid-word. I do apologize. I did explain it to him, and when I handed it, when it went back to him, I didn't have it to look at. I would have hopefully figured out that error. Sorry. If fails to successfully complete PTI, will go directly to sentencing.
So, Mr. Castillo, you are still under oath from earlier today, so you've been consulting with your attorney regarding the plea and sentencing agreement that I see you signed.
Yes.
And do you understand the terms of the plea agreement as explained to you?
Yes, sir.
So you've got a separate pretrial intervention. If you succeed to complete that, there's no reason you can't. Then the case will actually, all these charges will be dismissed, which will be very beneficial for you. But if you don't, you go right to sentencing, and there are a number of charges that are contained here, so it's a real wide difference between those two outcomes. So you need to pay attention to that, okay?
Okay.
And you understand this will be a final resolution of this case, though?
Yes, sir.
Okay. And you're doing this freely and voluntarily, you've had all your questions answered?
Yes, sir.
Based upon that, the court will accept the plea and sentencing agreement on the pretrial intervention. If you successfully complete, will be dismissed. If not, we'll go straight to sentencing.
Thank you, Your Honor.
Thank you.
Have a good day. Thanks for courtesy, Your Honor.
Thank you, Your Honor. That completes my business report today. Thank you.
Thank you for filling in. I know Ms. Sharpless greatly appreciates it.
I'll see you on Monday. Thank you, sir.
I know there'll be payback. Dave, apparently the storm's about ready to hit, so I hope you avoid the full rain before it hits.
Be careful.
Thank you. Appreciate it. Yes, I think Your Honor, I am not, may I address the court? Because I am just simply standby counsel. My request would be to sit at the far end of the table and he can sit here. I don't want to imply that I'm advising him in this proceeding.
I understand.
Thank you.
Okay, good afternoon. We're here on case number 14 CF 2050. This is a Rule 3.850 evidentiary hearing. There's a number of procedures that have occurred. I just want to frame up the issues to make sure we're all on the same page. We are addressing here today this evidentiary hearing only as to grounds 3 and 5. And that's what we're going to be focusing on. Ground number 6, I believe, was withdrawn at the last hearing, and then earlier Judge Polson, my prior judge, on August 5th of 2022 denied the defendant's other claims, which are grounds 1, 2, 4, 7, 8, 9, and 10, and 11. So, with that, the way we will proceed, you've been, before I go though, I guess I'm obligated again. I think I understand what the response is going to be, but Mr. Bryan, I'm required to again ask you if you wish to have the assistance of counsel. Once you pull that, can we pull that mic for him so he can...
Oh, I'm sorry, I had the other mic ready for you. I was trying to get his response there. So, again, are you wanting to continue without benefit of legal counsel?
Yes, Your Honor.
Okay, and you believe this is in your best interest to do so?
Yes, sir, Your Honor.
And do you feel like you've got adequate legal training or legal understanding in order to do this?
Yes, sir, Your Honor.
Yes, probation. And it's dismissed. Thank you for being here all day. It's a long day. So, at the last hearing, Mr. Bryant, the court appointed, I believe it was at your, not necessarily your request, but at your acquiescence, Mr. Medina, who's with the Public Defender's Office, to act as standby counsel. Standby counsel just means that if you feel during the course of this hearing that you need or wish to have legal counsel, you can draw on that. But unless that's specifically requested, he's staying out of the way, not going to interfere with your presentation here today, unless you request specifically. And again, just a reminder of my prior. Today, you are operating pro se. Pro se is, a lot of people think that, and may have heard me say this, they think that it means that you're here without an attorney. It actually doesn't mean that. It means you're here operating as your own attorney. So you're wearing two hats here today. You're wearing the hat as one of the parties, obviously, the defendant, and you're here also as the defendant's attorney. And in that role as a defendant's attorney, I've got to treat you as any other attorney. So I can't give you any advice. You're still required to abide by the rules of evidence procedure as we proceed through the day. Okay?
Yes, Your Honor.
Any questions regarding any of that?
No, sir, Your Honor.
Okay. Before we start anything, Ms. Bossa, before I allow Mr. Bryant to make any opening statement he wishes to make.
Nothing from the state this time, Your Honor.
Mr. Bryant, you can make an opening statement if you wish, and you're welcome to continue sitting there if it's more comfortable. I know you're kind of constrained a little bit. You're fine to just sit there if you wish. If you go ahead.
And Your Honor, I'm sorry, if I may, just procedurally, we believe the burden is on Mr. Bryant to go ahead and put on evidence. So I don't know if the court wishes to swear him and he wants to proceed that way.
Well, I'm going to let him make I'm going to allow him to make an opening. Thank you for asking that question. I'm going to allow him to make an opening statement as attorney Bryant. You're not an attorney, but operating and representing yourself. And then at that point, I'm going to ask you whether you wish to put on any evidence, in which case if you are going to speak at that point by way of putting in evidence, I'll swear you in.
And there's one other housekeeping matter.
Yes,
Your Honor.
ma'am.
As this is a 3.850 and a claim of ineffective assistance of counsel, we've asked that Mr. Bryant affirmatively waive any rights as to attorney-client privilege as to anything regarding these specific allegations that may arise today.
Mr. Bryant, do you understand what you just said?
Yes, Your Honor, and I agree to that for the purposes of this hearing.
Thank you, sir.
Thank you. Mr. Bryant, do you wish to make an opening statement? Or you wish to just proceed to put on evidence or present evidence? How do you wish to proceed?
Your Honor, I believe that my motion and record already states or stipulates the grounds that I'm proceeding on, and for the most part, they speak for themselves. Ground 3, of course, relates to a matter of hearsay, and ground 5 relates to a matter of a subpoena and how it was utilized. And since the motion is already in record, I feel that I would just be more or less rereading what I've already written to include any of that in the opening statement, so I'll let it speak for itself within the record, Your Honor. And
so let me ask you this, are you planning to put on any evidence here today?
At this point, I would probably just call my witnesses and see where that goes, Your Honor.
Okay, that's your evidence.
And
do you wish to call your first witness?
Yes, Your Honor. If it will please the court and the state.
Okay, so you're basically waiving your opening statement because you filed your motion, waiving your opening statement, and you wish to proceed to put on your evidence, call your witnesses.
Yes, Your Honor.
Okay. Who do you wish to call first?
I would like to call Michael Weinstock to the stand, Your Honor.
Mr. Weinstock. Madam Clerk, would you please swear the witness?
Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I do.
You may proceed, Mr. Bryant.
Yes, sir. And I'm sorry, I should have said this before, but I would beg the court's indulgence, since I'm restrained, that it might take a little bit of time in between one document and the other, how I move about.
You do not have to apologize for that. I understand.
All right, thank you. Good afternoon, sir.
Good afternoon.
Would you please state your name for the record, sir?
Michael Weinstock.
You pull that mic down to you, Mr. Weinstock. Pull the mic closer.
Michael Weinstock.
And Mr. Weinstock, what is your profession, sir?
Attorney at law.
Attorney at law. And is that Florida law, federal, military?
Florida.
Florida law? And how long have you been in practice, sir?
Over 20 years.
Mr. Weinstock, speak into that mic, directly into the mic like this. Thank you.
Over 20 years.
Over 20 years. So as of 2014, it would have been over a decade then?
That's correct.
Yes, sir. So you were my attorney for the case 2014 CF 2050, sir, correct?
Correct.
All right. Have you had the opportunity, just for convenience sake, to read over my motion before today?
Yes, I did.
All right. And I know it's been quite a while. Would you say you're fairly familiar with the facts of the case and the arguments that I brought forth?
I'm familiar with counts 3 and counts 5 that you have in your motion.
And that would be sufficient for today, yes, sir?
Yes, sir.
All right. But you're familiar with the case itself, correct?
I'm sorry, with what?
The case 2014 CF 2050? I know it's been a while, but...
It's been a while, Jonathan, but yes, I'm familiar with what I've done on the case.
All right. If I could have a moment to confer with standby counsel, Your Honor.
Just for the record, Your Honor, I just wanted to make a statement that I'm not here to provide any substantive advice. My understanding of the limitations is it really only has to do with courtroom procedures. I do not think it's appropriate for me to micromanage direct questioning, so I might not be able to help, and I might bring that up with the court depending on what the nature of the question is.
Okay.
That might actually be, you know, I'll try this. Mr. Weinstock, I'd like to ask you a few questions about some of the testimony that took place during the case, during the trial itself. Would it be helpful for you to have a copy of the testimony in front of you?
Sure.
All right.
And Mr. Bryant, if I may inquire for the purposes of the record, what is it you're providing this?
Yes.
I'll take a quick. May I take a peek at it, sir?
Yes, ma'am. I actually have 3 copies here.
Oh, perfect. Okay. Thank you.
What is it you're handing the witness?
I've handed him the transcript of the trial itself, or a portion of the transcript of the trial, pages 245 through 252. I believe that was volume 6 of the Record on Appeal, volume 2 of the trial transcripts themselves.
Okay.
And
I'm sorry?
Do you need to see a copy?
Not right now. I don't know. Did you have an extra copy?
I brought 3 copies, which was silly because
That's fine. Don't go ahead and ask your.
And also for the record, I have underlined sort of rudimentary style certain lines that I wish to point out to the witness.
And I'm sorry, I hate to keep interrupting, but I want to perfect the record. Sir, this doesn't identify who the witness is that's testifying in the transcript. If you could please do that for us.
Oh, yes. Yes, ma'am. Your Honor, this would be the direct questioning of Detective Chris Wilkinson.
Okay. Is this direct questioning by Mr. Weinstock?
By the state, Your Honor.
By the state.
Yes, sir. And the lines in question will be on page 245, lines 20 through 25, and on page 247, lines 7 through 10, at least at the outset. Before I refer to the testimony, Mr. Weinstock, you were my attorney of record for this case throughout the vast majority of the proceedings, correct?
Yes, sir.
So this also meant that you had time to go over the probable cause statement, the arrest report, and such, correct?
That's correct.
Did you also do the depositions in my case?
Please repeat.
Did you also perform the depositions in my case?
Yes.
All right. So for the purposes of the one moment, Your Honor. Mr. Weinstock, I would I would actually prefer to address the lines that I've highlighted on page 248 first. That's lines 9 through 20.
I have it in front of me, yes.
What's your question?
So, and if I may ask the court, would it be better at this point for me to read the lines into the record for the witness to do so, or will the record speak for itself on this?
This is your presentation, counsel. You can do as you believe is best.
All right. In that case, I would like to read the lines aloud and then ask the witness a question about them. Line 9, now in this particular case, skipping to 12, did you get information back related to the IP address related to that file? And the answer was, I did. Question, what information did you obtain about that IP address? Answer,
excuse me, what page are you on?
I'm sorry, I'm on page 248.
And what line are you reading?
Lines 9 through 20.
Okay, then you're reading something that I don't have. Line 9 on page 248 says, now in this particular case back on April. Is that what you have?
Yes, sir.
Okay, that's not what you just read, was it?
I skipped down to line 12 partway through.
So are you reading from line 12?
Yes, Your Honor. And so, picking back up from line 12, did you get information back related to the IP address related to that file? Answer was, did. Question, what information did you obtain about that IP address? Answer, it came back to the lessee of that particular IP address, or the person whose address was using that IP address who was in Niceville. Mr. Weinstock, my question is, as that was the direct line of questioning by the state, why didn't you object to it on the grounds of hearsay?
Well, as far as I remember, Mr. Bryant, there wasn't hearsay. I believe that the subpoena that went out to Cox was reviewed by, and the result was reviewed by this deponent, Wilkerson. So he's saying what he saw on the paperwork that came back from Cox. So that's not hearsay. He's just saying what he knows, not what someone told him, but was on the paperwork from the subpoena.
All right. Now, on the subject matter of the subpoena, did you have an opportunity to review that over the course of the case?
Are you talking about your ground number 5?
Yes, Mr. Weinstock.
Yes, I have.
And so I'd like to ask you, why didn't you object or file a motion to bar the introduction of the evidence obtained during the search warrant resulting from said subpoena?
Well, Mr. Bryant, I went through my files prior to today, and I see that in August of 2015, I filed a motion to suppress evidence relating to the unsigned affidavit.
Yes, sir.
And it was calendared with the judge's docket to be heard. Prior to it being heard, however, I got from the state a signed copy of the subpoena of the warrants and that stuff. And therefore, I withdrew my motion to suppress because a signed copy came through. And I figured I was just spinning my wheels.
And Mr. Weinstock, that was actually the argument under ground 6, which has been withdrawn. What I'm actually asking about is why didn't you move to suppress it on the ground of there not being a subpoena properly issued?
Well, when I prepared my petition, my motion, to suppress the evidence, the fact that it was unsigned to me was the grossest error. And therefore, that would have been a winner from day one. There's no need to compound it completely. So I just put the most egregious issue, the fact that there was the unsigned document, and that's how I proceeded on that.
But eventually you withdrew the motion?
I withdrew the motion because I got a signed document returned to me by the prosecutor, Jennifer Lieb.
Then after withdrawing that motion, why did you not file on the grounds of the subpoena not being valid or not being issued? If I may.
Let him finish answering the question.
Yes, Your Honor.
You understand the question, Mr. Weinstock?
Yeah, I do. I'm trying to recall, Mr. Bryant, at this point, I don't remember, I don't know the answer to your question. That was 9 years ago.
Yes, I understand that. Would it help if I provided the document in question?
Anything would help, perhaps.
All right. And I do have 3 or actually 4 copies with me as well of this one.
And Your Honor, whether it's an objection or just a motion for clarification, I would just ask, no objection to that. I would just ask that Mr. Bryant be clear as to when he says a subpoena, what subpoena are we talking about? Just for clarity's sake, because I believe it's confusing the witness as well, sir.
Yes, Your Honor, I think I was a little overly vague with that one.
Okay.
Specifically, Mr. Weinstock, I would like to ask you these questions about the subpoena to obtain the IP address itself that precluded the investigation moving forward to the search warrant.
You said precluded, you mean preceded?
Yes, I do mean preceded. I am stumbling over words today.
All right, sir. I've got this Homeland Security summons to Cox Communication asking for information. What is your question, sir?
And would the record reflect that this is the document that was submitted by the state in their response to my motion as part of, I believe it was the first attachment? Mr. Weinstock, have you seen this document before?
I believe so, yes.
And was this provided to you as part of the subpoena and return by the state?
I believe so, yes.
And after receiving this document, you did not file a motion to dismiss the information for lack of subpoena, or not the information, but the evidence obtained by the search warrant, correct? For lack of subpoena.
Mr. Bryant, forgive me, I don't understand your question. I don't want to sound, I'm not trying to be belligerent, but I just don't understand what you're trying to say to me.
Yes, sir, I'll rephrase. You have seen this document before pertaining to my case?
Yes, sir.
And you did not file a motion to dismiss the evidence acquired through the search warrant or to suppress it from use at trial after seeing this document, correct?
Well, this document was part of my motion to suppress evidence that I submitted back in, like I mentioned, back in August 15, August of 2015, where I included the affidavit search warrant as attachments A and B in my motion to suppress. And as I mentioned before, that when I received the signed copy back, I figured everything was valid, and therefore I didn't pursue it any further from that point.
Your Honor, I have no further questions at this time for this witness.
Ms. Bossa.
May I stay here as well?
You may stand, sit, or use the podium as you wish.
Thank you, Your Honor. Okay, if I may I approach?
Talk into the microphone.
I'm sorry. Okay, I should remember that, shouldn't I? May I approach the witness with what I'm going to mark as State's Exhibit number 1 for identification purposes? I will show it to Mr. Bryant, but Mr. Bryant, sir, this was also included as part of my attachment. It is a copy of the residential search warrant and affidavit.
Yes, ma'am.
Thank you. And I'd like to approach the witness with that, Your Honor.
Do you have an extra one for me?
Yes, I do. And it's actually, Your Honor, it is attached to my original submission, but I do have an extra copy for the court. State's one, Your Honor.
Thank you.
And Mr. Weinstock. Sir, I'm showing you State's Exhibit number 1. That this is the affidavit. Am I messing up here?
Ms. Also, it's going to sound funny, but I can hear you better over there in the microphone than we can right next to me.
All right. Mr. Weinstock, I've handed you what's I marked as State's Exhibit number 1, the search warrant and affidavit that Mr. Bryant is challenging in count number 5.
Yes.
So are you familiar with that document?
Oh, I've seen it, yes.
Okay. So I'd like you to turn to what is going to be marked as page 1 of the actual search warrant. For following purposes, that I believe is going to be the 5th page of this package. The top says the facts to support a finding of probable cause are as follows.
I have it in front of me.
And sir, towards the bottom of that, it indicates that on April 16th, 2014, the case was forwarded to Special Agent Nancy Andrews with the Department of Homeland Security in Pensacola. Special Agent Andrews on April 16th, 2014 served a subpoena to Cox Communications as to who maintained the leased IP address 174.69.15.106 for the dates between April 14th, 2014 and April 17, 2014. And then it goes on to say that Ms. Jacqueline Murray, the subpoena specialist for Cox, provided the following information. I've just paraphrased that. And that indicates that that particular IP address on those dates came back to an Isle of Bryant, 518 22th Street, Niceville, Florida, 32578. Would you agree with that, sir?
That's what it says, yes.
Okay. And sir, you also were provided in discovery, and I'm going to bring you a copy of this. Just trying to get the extra copies for the court. this is State's Exhibit number 2. I believe it's the same thing you have, sir, which was the summons to Homeland Security
Yes, ma'am.
and also the return from Cox. And you've seen that as well, is that correct, sir?
Yes, ma'am.
Your Honor, I'm approaching the witness with State's Exhibit 2 and 3, and I'll give the court a copy as well. These were attached to our original. And Mr. Weinstock, sir, have you seen those particular documents as provided in discovery from the state?
Please repeat your question.
Yes, sir, that is the subpoena and summons from Homeland Security to Cox Communications and the return provided by Cox Communications. Have you seen those before, sir? As part of the discovery?
I recall what you have annotated State's Exhibit 2 for identification. It's not an exhibit yet, is it?
Actually, I'd ask that be amended evidence, Your Honor, State's Exhibit 2 and 3.
Any objection?
No objection, Your Honor.
Without objection, the court will enter State's Exhibit 2 and 3. Did you admit
I was just going to
State's
say
Exhibit 1?
for housekeeping purposes, I'd also ask for State's Exhibit number 1 to be admitted in evidence if it hasn't already been.
No objection, Your Honor.
Without objection, the court will admit State's Exhibit 1 as well.
As for State's Exhibit 2, which is the summons by Homeland Security, I recall that. In fact, that's the same thing that Mr. Bryant just gave me on defense, one of his exhibits. As for the Cox printout, at this point right now, I honestly don't remember this.
And I believe that was actually provided to you at a deposition of Investigator Evans, and it's reflected in that deposition. Does that sound accurate?
Ma'am, I don't recall. 9 years ago, I just don't recall. I'm sorry.
Let me rephrase the question. And based on those documents before you that are part of evidence, if you had seen the Cox summons or subpoena that we have there and the return, then would you have any reason to question those paragraphs that I read to you in the search warrant that indicate that Nancy Andrews issued that summons and then received the return that came back to your client's address?
I would not.
So therefore, based on that, sir, would you believe there would be any reason to challenge the search warrant on those grounds?
No.
Thank you, sir. I believe, Your Honor, that's really actually all I have for Mr. Weinstock.
Anything further, Mr. Bryant, for Mr. Weinstock?
No, sir, Your Honor.
Please step down. And is Mr. Weinstock free to leave, or does he need to stay around?
Your Honor, the state would have nothing further. It may depend on if any witnesses are called by Mr. Bryant that I might need to have Mr. Weinstock here for. I don't know who he might call. So if we could just ask him to stay for a
Okay,
longer
you can
period.
stay with us just for a little while longer, Mr. Weinstock.
We won't make him stay for argument. How's that?
Mr. Bryant, who do you wish to call next?
At this point, I would like to call Mrs. Isla Bryant to the stand.
You don't want to keep the hearing device? You might need the hearing device.
I'm sorry, Your Honor. Did Mr. Bryant wish these items to be considered evidence that he presented to the court, or were they just aids?
This case, I'm not Would the
If you remain standing, raise your hand.
the clerk swear the witness?
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Your Honor?
Yes, sir.
As a housekeeping matter, I would like to ask that the exhibits I handed Mr. Weinstock be admitted into evidence.
What exhibits were those?
Those were the trial testimony of Detective Chris Wilkinson and the Department of Homeland Security summons. And I would
This
ask...
is the same as the state's Exhibit 2, right?
Yes, Your Honor. I would ask that they be admitted as defense exhibits A and B, respectively.
State?
Without objection.
Okay, so the summons is defense's Exhibit A, and the testimony is B. You want to put your idea?
The transcript testimony?
The transcript.
Yes.
Do you have copies of it?
No, sir, nobody handed me anything yet.
We need the copies.
I get copies for the clerk of each. Your Honor, I would actually ask that they be admitted the other way around, since I presented him with the testimony first.
The testimony will be defense's Exhibit A, and the summons will be defense's Exhibit B as in boy.
Okay. So the summons is
B is in boy.
Okay.
The other one is A.
All right.
Okay, you may proceed.
Thank you, Your Honor. State.
Ma'am, if you have any problem hearing, just wave your hand. So, because we want to make sure you understand what's going on here.
Yes, sir.
Okay. Mr. Bryant.
Good afternoon.
Good afternoon.
Would you please state your name for the record?
Isla Colleen Bryant.
And what is your relationship to me?
I'm your mother.
So, as my mother, is it safe to say that you have an interest in the outcome of this hearing?
Most certainly.
Do you still intend to follow the oath that you just gave to tell the truth and only the truth?
Yes, I do.
Thank you. Your Honor, at this point, I would like to present the witness with actually 2 copies of the same document, but with one alteration. And I have a copy for the state and for the court as well.
I'm sorry, I'm not clear what you're handing us.
This is a power of attorney.
Okay.
There. Ms. Russo, did he hand you 2 copies of it?
No, I only got one. I got a copy of the power of attorney.
Yes, I apologize.
Sorry.
Yes, there's a difference there, but I want to ask the witness about that to put it on the record first.
Are these 2?
These, those are 2, and
I see those are 2.
yes.
Thank you.
So at this point, I would like to ask you, did you author the documents before you?
Yes, I did.
Now, are they basically the same document?
Yes, I believe they are.
With the exception of,
Telephone number.
is that a home phone number that I blanked out on the one?
I don't recognize that number.
Would that number, would you say that that number on that document is a social security number, perhaps?
Oh, it is.
All right.
Yes, that's yeah, that's secure.
And for the record, what is that document that is before you?
A power of attorney, a complete authorization for anyone to sign, for this person to sign my name in any situation.
Thank you. Your Honor, at this time, I would ask for the submission of the document that has the blanked out Social Security as Defense Exhibit C. And for the court's purposes, I blanked out that Social Security number just because I know these records are publicly accessible and I would rather not have my mother's Social Security number that easily available.
Are you wanting to offer these as exhibits?
I would like to offer the version that has the blanked out social security number as an exhibit.
And that would be C, as in cat, who wish to admit it in evidence?
Yes, Your Honor.
Any objection?
Yes, Your Honor, the state doesn't see any relevance to this document as to why we're here today.
What's the relevance, counsel? Mr. Bryan.
Your Honor, I wish through this document and through testimony to establish standing to challenge the grounds of the search warrant.
Your Honor, that's not what we're here for.
So, say that again, Mr. Bryan. You're here to do, what do you want this power of attorney to do?
I believe that through the power of attorney and the testimony that I believe that this witness will provide, that I will be able to establish that I had standing to object to the search warrant, which to answer the state's next objection, was acquired through the subpoena, or as an after effect of the subpoena, which I'm challenging in ground 5 effectively.
I don't understand the connection between the power of attorney and the subpoenas that were issued. What is the connection between those two?
The connection is that during the time frame that the IP address was acquired, or rather that the IP address was in my mother's name, but the power of attorney would establish that I had grounds to conduct any legal business or any financial business, including contracts with said company, and that therefore that would be pertinent to establishing standing to object to any evidence procured as a result.
It's possible.
Your Honor, I don't believe he would have had standing to challenge the summons from Homeland Security to Cox Communications one way or the other. And he's here because, we're here today because he said Mr. Weinstock was ineffective for failing to challenge a search warrant for subpoenas that did not exist, basically. But we've established that they did exist. So I don't believe that this is relevant, and I don't believe that it's even an accurate statement. Cox Communications does not reach out to its subscribers and ask, can we release these records? That's not how that works. It's not like a medical record. They respond to the subpoena as to who had that IP address on that date as is contained in their records. That's what they're responding to.
And
I'm going to, rather than engage in arguments about this, I'm going to allow him to ask questions. And if you wish to object on that, I think that would be the better time to object if if the questioning is not relevant, which I think is what your objection is.
Yes, Your Honor.
so for the record, is this document entered as Defense Exhibit C, or is that still pending the outcome?
I don't think it's been, I'm going to withhold the admission of it. You can inquire about it further.
Very well, Your Honor. I would like to ask that the document that has the visible Social Security number in no case be made available, though.
It's not being offered, so it won't be made available.
Thank you. So, Mrs. Bryant, you alluded to it before, but what does this power of attorney, what is its function?
Well, it gives the right for you to sign in case of my medical or financial obligations for legal signature.
And does it also cover business affairs?
Yes, it does.
include any contract business you have or had of any nature, correct?
That's any legal signature that's required of me.
Thank you. And was it valid from the time frame of April the 1st through July 30th of 2014?
Yes, it was.
All right. I believe that's all I have for this witness, Your Honor.
I don't think I really have anything, Your Honor, because I still believe this is a relevant testimony, so.
And Your Honor, if I may, if it helps, the relevance of this testimony hinges entirely on whether or not my arguments for ground 5 ultimately prove to have merit. I do believe that those will be addressed in legal argument at the end of this hearing. And so rather than rule on the relevance of the testimony at this time, I would ask that, if necessary, we postpone ruling on that matter until we've addressed the remainder of ground 5.
Your Honor, may Mr. Weinstock be excused? Are you planning on calling in?
You're the one who wanted to hold it.
Are you planning on calling in witnesses, sir?
No, ma'am.
He can be excused then, ma'am.
So why not you're excused for that?
Thank you, Mr. Weinstock.
You may step down, man.
Thanks, man. We're going to give that back to your son until it's
I'm not sure this is relevant testimony that we just received, but at this point, I'm going to allow it in and see where we'll go from here. Yes, that's exhibit C.
Okay, yeah, thank you.
The one with this one that has the number is not right. You have that?
Yeah, I'll agree with the social security.
Yes, sir.
And I appreciate the court and the state for returning the copies that have the visible social security number.
Who do you wish to call next?
Your Honor, I have no further witnesses at this time.
So you're arresting?
Yes, Your Honor. The defense rests.
Ms. Foster, do you have any witnesses?
Your Honor, the state hadn't intended to call Mr. Weinstock and place the items into evidence that we've already done through our cross-examination, so no, we have no witnesses at this time.
Okay. You make any closing remarks, Mr. White? State rests?
Yes, Your Honor, the state does rest.
Mr. Bryan, do you wish to make any closing remarks?
Yes, Your Honor, I do.
Okay, you may proceed.
Thank you. I may feel more, I apologize, this chair is perhaps a little too comfortable. I may feel more comfortable standing for this.
You may stand. You can stand at the podium if you wish.
Please the court. Ms. Marcel. We're here on grounds 3 and 5. As the court accurately stated, the other grounds were either denied a hearing by a predecessor or, in the case of ground 6, were withdrawn at a previous hearing on this matter. And your predecessor, in granting the hearing on these grounds and denying the hearing on the other grounds, I would like to say in her order denying those grounds, she was rather thorough in her legal reasons for doing so. I know that that is not perhaps binding on the court, but I do feel that that offers some amount of deference. As it pertains to ground 6, or I'm sorry, I just saw the number, ground 3. The witness, my prior attorney, I'm getting ahead of myself. I apologize. I do want to reiterate that the standard for ineffective assistance of counsel is the Strickland standard, and it's 2 prongs. I have to prove that the attorney was deficient in his performance. That is, that it fell below the prevailing professional norms. And then I have to show that that deficiency prejudiced the outcome of the case such that there is no longer confidence in the outcome. I believe that as a matter of law, I've satisfied those matters on ground 3. The witness did not object to the testimony offered by Chris Wilkerson that was previously read into the record by myself, admittedly, on grounds of hearsay. He didn't object because he did not believe that it was hearsay. Therefore, it was not a trial strategy that he employed. It was his interpretation of law, which this court must review de novo. As a matter of law, those statements quite simply were hearsay. The witness, Chris Wilkerson, was not testifying to matters that he knew himself. He was testifying to something that was told to him by another person. He did not submit the subpoena himself. And I cited in my motion as my primary case, Leonard v. State, 192 Southern 3rd, 1258. And that case is honestly very close to on par with my case, where the detective, this is at 1260 in that case, the detective repeated info that was told to him by a person or persons unknown from a tag agency. The district court ruled that that was hearsay under Florida Statute 90-801, subsection 1, subsection C, and also not based on personal knowledge. That's 90-604. Your Honor, the only thing that jumps out at me is that perhaps in my writing of ground 3 by itself, I didn't go far enough. In ground 3, I posited that a new trial was the proper remedy for this. And that was because without the hearsay testimony, the address in Niceville, there was no tie to myself and to the allegations made in count 1. There were simply allegations that were left hanging without anyone to attach them to. But on page 39 of my motion, and I'm getting a little ahead of myself by addressing the conclusion, but on page 39, my motion posits that, or rather requests the relief that I requested in the grounds. However, it also requests all the relief that the court deems appropriate, and that if the court deems there to be some relief that is more, or rather that there are reliefs that conflict, that the more appropriate, or rather the better relief be granted. Your Honor, in light of the fact that the hearsay testimony was the only thing that the state could have relied upon to prove the allegations of count 1, had my attorney at the time, Michael Weinstock, objected to the hearsay testimony and obtained a curative instruction, there would have been no evidence whatsoever to prove that count. So the rather more effective remedy would be the dismissal of the charge entirely, like the vacation and entry of an order of acquittal or the like. And I cite for that proposition of Polborough v. State. That's 103 Southern 3rd, 221. That was a 4th DCA case. And at 224, in their conclusion, they also granted a new trial. But they stated like this: had the trial court ruled correctly on the defendant's hearsay objection, the state might have been able to establish identity by another means. We therefore reverse and remand for a new trial. And that therefore indicates that had the state not been able to produce other evidence, the remedy would have been a vacation of the charge entirely. And that is as to ground 3. As to ground 5, and this is where things are perhaps a little trickier, the document entered into evidence as Defense Exhibit B and State's Exhibit 2, the Department of Homeland Security summons, is quite simply a summons. It's an administrative summons authorized by, I believe the statute written on it was 19 United States Code Section 1509. But that was not the proper way to obtain my IP information or my mother's IP information or any subscriber information in Florida under either federal or Florida law. Under federal law, that is under 18 United States Code 2703, and under Florida law, that is under I apologize, my paper's moved around here. Let me have a minute to look through my notes because I know it's here, Your Honor. Yes. That is under Florida Statute 934.23.
I'm sorry, what was what?
934.23.
Okay.
And specifically under subsection 4 and subsection A and B. Quite simply, a warrant, court order, or subpoena was required to obtain IP address information. Without that information, there could have been no search warrant obtained to search the address given in Niceville. Under the fruit of the poisonous tree doctrine, therefore, my former attorney could have filed to suppress the search warrant, the interrogation, everything that followed on the grounds of illegally obtained IP address. And that, Your Honor, is therefore why I wish to question my mother and prove standing that I could have objected to the obtaining of that IP address during that time, or rather during the trial that followed, as the obtaining of the IP address corresponded with the time frame that the power of attorney was in effect. And the fruit of the poisonous tree doctrine is cemented under Walton in the United States. That's 371 U.S. 471. And at 485, the United States Supreme Court quoted another one of their cases, it's Silverthorne Lumber Code, the United States, and they gave the rest of the citation, but that is in Wong Sun at 485. And they quote themselves saying, the essence of a provision forbidding the acquisition of evidence in a certain way is that not merely evidence so acquired shall not be used before the court, but that it shall not be used at all. So my allegation for round 5 is that my attorney, having seen the document, should have known that it was not a subpoena, it was a summons, and therefore did not comport with the requirements of law, and therefore could not have been used to obtain any further information. And that certainly that information should not have been admitted in the trial itself. And the proper remedy for that would be a vacation of the charges, and in theory it would be to remand that for a new trial without the use of the evidence obtained, but since without that evidence there could be no conviction, I would ask the court to simply move forward to dismissing the case entirely on that ground. And, Your Honor, I believe that's all I have for my direct presentation.
Do you wish to make any closing remarks on behalf of the state?
Yes, Your Honor, we do. We do agree with the defense in the fact that the Strickland standard is the appropriate standard to apply in this case to determine whether or not the defense request should be granted. We do believe, though, as to the first prong of whether or not Mr. Weinstock provided effective assistance to counsel and behaved as a reasonably competent attorney would do in those same or similar circumstances, we believe that we have shown that he did. Specifically as to count 3, Mr. Weinstock did testify that he was in receipt of the Cox Communications summons that was issued by Homeland Security and also by the return, and he was also aware through depositions that Mr. Wilkinson had reviewed those particular documents. So when Mr. Wilkinson testified on the stand, as Mr. Weinstock stated here today, Mr. Wilkinson indicated that yes, those subpoenas had been issued and that they came back to the IP address. Mr. Wilkinson, or Investigator Wilkinson, had personally reviewed those documents. Mr. Weinstock was aware of that, and therefore, as he stated, he was testifying from personal knowledge as to what he had seen and reviewed, that those documents came back to an IP address in Niceville, Florida. So we believe that he was accurate in not objecting based on hearsay. However, the second prong of that test was that the defense must show that there would be prejudice or substantial change in the outcome, but for the deficient behavior of his attorney. In this case, if he had objected, then the state could have very easily cured that. The state could have very easily then gone ahead and put the Cox subpoena in as a business record, because that's how it was returned, and as the court knows, that is an exception to the hearsay rule. And then Mr. Wilkinson could have testified off of that document. But we do believe that it is appropriate that he found that it was not hearsay, because Investigator Wilkinson was testifying from personal knowledge as to what he had reviewed. But the second prong, we believe, would not have been met because the state could have cured that particular thing even if he had objected. So there would not have been a substantial change in the outcome. As to ground 5, again, the court has before it the documents, the Cox subpoena, the summons from Homeland Security. We disagree with Mr. Bryant. We believe that was a duly issued document from the Department of Homeland Security that was presented to Cox Communications for subscriber information. That is what they provided back, and that was returned as a business record. So we do believe that that was a valid request by law and that it was properly returned. Based upon the fact that Mr. Weinstock knew that that subpoena from Homeland Security had issued, that the return was provided, he had no reason to challenge the actual search warrant based on those grounds, because he did have reason to believe that that was legally obtained information and that it was incorporated into that search warrant that was ultimately then signed by a judge and allowed Investigator Evans and the rest of OCSO to search Mr. Bryant's home at that time. Your Honor, we do believe that Mr. Bryant has failed to establish that Mr. Weinstock's performance did not rise to the level of competent counsel. We do believe he acted appropriately in both of these cases that have been challenged based on the testimony that was provided and the documentation that was provided to the court, and we ask that Mr. Bryant's motion be denied at this time, sir.
Very good. Okay. Thank you all very much for your presentation here today. The court will take this under advisement and will prepare an order when the court makes its decision.
Thank you, Your Honor. And, Your Honor, as
you have all the documents?
No, I don't. I need the state's exhibits, Your Honor. 1, 2, and 3.
They may have been left up on the stand by Mr. Weinstock. Go ahead, mark them. Are there any up there?
No. I mean,